this year to publish the full and final legal advice by the Attorney-General to the Cabinet concerning the EU withdrawal agreement and the framework for the future relationship? Yes or no? That order was binding. Mr. Speaker, on the 13th of November, I sought your advice on that issue, and you ruled in the following terms. The ruling I give is simply that the motion is effective. I have been advised thus. It is not an expression of the opinion of the House, it's an expression of the will of the House that certain documents should be provided to it. Yesterday, the government published a reasoned position paper. That was not legal advice. It simply described the deal. It was a synopsis. It was in the nature of an explainer having already been published when the deal was published. It was a long way from legal advice. The Attorney made a statement to the House, and then he answered questions. But the government did not publish the full and final advice by the Attorney-General to the Cabinet. Mr. Speaker, that is the long and short of it. The government is wilfully refusing to comply with a binding order of this House, and that is contempt. Mr. Speaker, yesterday the Attorney-General as good as admitted it when he said, and I quote, "I wish that I could comply with the request of the House, but if I did, I sincerely believe it would not be in all our interests." And slightly later he said, "Although the House says I should disclose, I believe that the public interest compels me not to do so. I'm sorry." Mr. Speaker, that's a plea of mitigation, it's not a defence. I make 3 points about the government's position. First, as the honourable member for North East Somerset made clear yesterday, for the Attorney-General to say that in his view it's not in the national interest is not good enough. The honourable member for North East Somerset went on to say, and I quote, "When the government loses a vote, they must follow the will of this House under a humble address, according to all precedent. It is no longer a matter for the government to judge. It has been decided by this House, which is a higher authority." Mr. Speaker, my second point is this. If the Attorney-General feels so strongly about this matter that he is prepared now to put the government in contempt of Parliament for refusing to comply with a binding order, why on earth did he not vote against the order in the first place? Or anybody else on the government benches? That wasn't an oversight. The government knew very well what was being asked for. The Attorney-General must have known what was being debated and voted on. Yet it appears from answers given by the Attorney-General yesterday that he was not asked before that vote for his views on the wisdom of not voting against the order, nor did he offer any advice, directly or indirectly. Again, Mr. Speaker, I quote the Attorney-General. "I had no discussion with the Chief Whip on this subject. None was sought." Now, I don't doubt the Attorney-General's word for a minute, but really? Before that vote, nobody asked the Attorney-General's views on the consequence of not opposing the order. The truth is that the decision not to oppose the order was a political decision taken by the government because it feared it would lose the vote. Mr. Speaker, they didn't want the short-term humiliation of losing a vote, and the price of that was higher than voting against the order. And none of them did it. Mr. Speaker, that's not for the first time. I will in a moment. That's not for the first time. For months, the government has ignored Opposition Day motions, and now their tactic has got them into very deep water indeed. The government cannot come to this House and say, "We took a political decision not to oppose the making of the order to publish the full and final advice by the Attorney-General, and then we took a decision not to comply with that order but somehow we're not in contempt of Parliament.
Sounds pretty contemptuous to me.
The third point I make, Mr. Speaker, is this, and it's about the government's amendment. It's about the government's amendment in the name of the Leader of the House, asking this House to refer the matter of whether the government's response fulfils the motion of the Committee of Privileges. Mr. Speaker, the short point is this: there is nothing to refer. A binding order was made and the government is refusing to comply with it. The reality is, yet again, by its amendment, the government is simply playing for time in the hope that this ends up in the long grass until the crucial vote is long gone. So, Mr. Speaker, this motion is extremely important. It has huge constitutional and political significance. Bringing the motion is not something I have done lightly. On the contrary, Mr. Speaker, on the contrary,
Order. I don't need somebody yelling rather stupidly from a sedentary position, give way. The Right Honourable and Learned Gentleman will give way if and when he wants to do so, and that's the end of the matter, and the same will apply when the Leader of the House is on her feet. Let me just make it clear, these are extremely serious matters, and the public is entitled to expect that this debate will be conducted with courtesy. However long it takes, that is what will happen. Keir Starmer.
Thank you, Mr. Speaker. I've not taken the decision lightly because I understand the constitutional and political significance of this motion. On the contrary, we have raised points of order on a number of occasions about this order. We've asked urgent questions, and I have repeatedly urged the government to reconsider its position, both publicly and privately, making it clear of the consequence of not doing so. But the government has chosen not to do so. I urge the government now, even at this 11th hour, to think again, to stop, to pull back from the brink of being found in contempt of Parliament. This motion, Mr. Speaker, is a last resort. The issue before us is simple. This House passed a binding order. The government is willfully refusing to comply with that order. That is contempt of Parliament.
Order. Yes, the Right Honourable and Learned Gentleman has very clearly completed his speech. The question is as on the order paper. To move the amendment, I call the Leader of the House, Andrea Leadsom.
I beg to move the amendment in my name on the order paper. In responding to this motion, I want to start by thanking my Right Honourable and learned friend, the Attorney-General, for putting himself at the disposal of the House yesterday for over 2 hours to provide information about the legal impact of the withdrawal agreement. He did so with his characteristic candour and integrity. The use of this motion has happened very rarely in the history of Parliament, and I don't think any member of this House can be in any doubt that the information that the Attorney-General provided yesterday was a very frank assessment of the legal position. The questions posed by members on all sides addressed the key issues we must all consider on the legal effect of the withdrawal agreement. And my Right Honourable friend responded to all of those questions in a comprehensive fashion. Alongside yesterday's nearly 2.5-hour session, the government has also provided a 48-page legal commentary which sets out the legal effect of each part of the withdrawal agreement. The information provided to the House is the detailed legal position on the withdrawal agreement, and as the Attorney-General said to the House yesterday, he continues to be at the disposal of parliamentarians to answer further questions. I would therefore, in responding to the contempt motion before us today, urge the House to exercise caution in this matter. The issue at hand is not one of substantive content. As yesterday's questioning illustrated, there is no real dispute as to the meaning and legal effect of the withdrawal agreement, and the Attorney-General could not have been clearer about the legal position yesterday. In fact, Mr. Speaker, no honourable member could say in all honesty that the Attorney-General has done anything other than treat this House with the greatest of respect. There can be no question that he or the government has acted in a manner which is contemptuous of this House.
I'm very grateful to her for giving way, and she says that the Attorney-General answered with candour. Indeed, he did, because he made it absolutely clear that what he was doing when he said, although the House says I should disclose, I believe the public interest compels me not to, he made it absolutely clear that he was, quite deliberately, in contempt of this Parliament.
Well, the honourable gentleman, in my opinion, is not correct. And as I have just set out, the Attorney-General answered questions from all members with the most frank and clear possible legal position. So the issue we are debating today is the government's duty to protect law officers' advice, which is in the national interest. I'll give way.
I'm very grateful to the leader for giving way. Does she share my disquiet with some of the sincerity spoken by the honourable and learned gentleman who opened the debate? The letter which he has tabled, calling for this motion, was signed and sealed by Thursday lunchtime yesterday. They clearly had on Thursday, I'm sorry. They clearly had no interest in what our right honourable and learned friend, the attorney, had to say on Monday.
Well, I agree with my honourable friend that certainly this House needs to exercise some caution, and I would like to explain precisely why. The issue we are debating today is the government's duty to protect law officers' advice, which is in the national interest. This House has previously recognised the importance of the principle that information cannot always be disclosed. This is always guided by the need to protect the broader public interest. This is directly reflected in the Freedom of Information Act of 2000, brought in under a Labour government, which sets out a careful scheme for balancing the twin imperatives of transparency on the one hand and of safeguarding the public interest on the other. The consequences of not following those principles are obvious. The House might request, by way of a humble address, information that could compromise national security or which might put the lives of our troops in danger.
Obviously, parliamentary sovereignty and the duty of government to obey motions is extremely important to this House. But my honourable friend is rightly saying there's another problem of the confidentiality of legal advice, which Labour and Conservative governments also need as well. Isn't there a sensible solution to this, as opposed to this party political exchange at the moment, that the opposition agree to receive a confidential briefing on Privy Council terms, look at the documents, and have the attorney point out those parts which, in everybody's view, might damage the national interest, damage the negotiating position of any government of any party, and, in effect, agree to redact the documents. The politically embarrassing bits, which is what the opposition are after, and all the rest of it, they can come out. But with both these conventions, that the House must be obeyed and that the attorney's legal advice should be confidential, ought to be protected, and that's a possible way of reconciling the two.
Well, I'm grateful for the advice of the Father of the House, but he will appreciate that the right honourable gentleman opposite wants all legal advice to be put into the public domain without any attempt at protecting the national interest whatsoever. and what he will appreciate, I won't give way for a while, the consequences of not following the principles of transparency on the one hand and safeguarding public interest on the other are very obvious. The House could request, by way of a humble address, information that could compromise national security. It would mean releasing information with no method for the House itself to review or assess the information in question before its full release into the public domain. It would not be possible under the humble address procedure to weigh up any potential consequences of such a disclosure. It is simply an irresponsible thing to do. Turning to the present case concerning law officers' advice. As this House is aware, this is the subject of very long-standing conventions which are enshrined in the Ministerial Code and recognised in Erskine May. Firstly, without the authorisation of the law officers, the fact that, or whether indeed their advice has been provided to government, should not be disclosed. Secondly, such advice must not be provided to those outside of government without the law officers' express authorisation. The purpose of these conventions are to provide the best possible guarantee that government business is conducted in the light of full and frank legal advice. This is a fundamental principle of the rule of law. If government knew that it might be forced to disclose the advice that it had received, it could seriously compromise the sorts of requests for advice that would be made, and it would totally impede the ability of the law officers and government lawyers to provide it. In turn, that would seriously compromise good government. This motion we're debating today would undermine these vital conventions, and it does so through the blunt instrument of the humble address, an arcane parliamentary procedure which until very recently was last used in this way in the 19th century. Moreover, there is real doubt about the ambit of the procedure. As I said earlier, it contains no mechanism by which information can be reviewed to ensure that its disclosure does not seriously harm the public interest. So in considering today's motion, honourable members must reflect carefully on this and on the potential consequences not just for this government, but for all future governments. As this House knows, the government has worked extremely hard to comply with humble addresses that have previously been passed. And we have also sought to do so in response to the current case that we're debating today, whilst at the same time taking steps to protect the national interest. The conventions that I've spoken about stand and endure because they respect the proper balance between the government and Parliament, and the principle that ministers should be as open with Parliament as it is possible to be, provided that disclosure of information does not compromise the wider public interest. We chip away at them at our peril. Today's motion is not in the interests of members, and it is definitely not in the national interest. What we break now may be very difficult to fix later. I turn now to the contempt motion itself.
Will the leader give way before moving on?
I'll give way.
I thank the leader for giving way. The leader has been commenting on the use of the humble address mechanism to compel the disclosure of information. We were told by the attorney yesterday this information would be prejudicial to the national interest. Isn't it impossible to debate openly in this House whether or not the information should be disclosed without knowing what that information is? And isn't it therefore more appropriate to make a decision about what may and may not be disclosed in some confidential tribunal analogous to a judge making that decision if a matter of disclosure arises in a court of law?
Well, again, my honourable friend points out the problem that the Right Honourable Gentleman's motion seeks for all information to be provided into the public domain without any ability of anyone on any side of the House to consider whether that would be in the national interest to do so. So I do want to turn now to the contempt motion itself. We recognise that concerns have been raised as to whether the government's response meets the terms and spirit of the motion agreed on the 13th of November. We consider that the spirit and intent of that motion has been fully complied with. As I said earlier, the government has now provided a 48-page paper setting out the legal effect of the withdrawal agreement, and the Attorney-General came to this House yesterday. Anyone present in the chamber for his statement and his subsequent responses to questions can be in absolutely no doubt that the Attorney-General gave a full...
Order. The Leader must resume her seat momentarily. Mr. Russell Moyle, you are a very excitable denizen of the House. If you were on your feet, you would be entitled to express your views. When you are in your seat, you are not. I hope that basic rubric is now clear to you and will require no further explanation. The Leader of the House, Andrea Leadsom.
Thank you, Mr. Speaker. Anyone present in the chamber for the Attorney-General's statement and his subsequent responses to questions can be in absolutely no doubt that the Attorney-General gave a full and frank exposition of the legal position of the withdrawal agreement. I simply reject any suggestion that the Attorney-General has done anything other than treat this House with the greatest of respect. Turning to process, the motion before the House today seeks to find the government in contempt of Parliament without having taken the important prior step of referring the matter to the Committee of Privileges, as is normally the case. This is a matter of due process. Firstly, those facing this extremely serious charge of contempt should each be given the opportunity to make their case and to follow the due processes of this House. They should be given the opportunity to explain how they have come to their decision about how best to balance the government's responsibilities to Parliament with their ministerial duties, including the need to consider the national interest. That opportunity is a vital element of any such procedure. And in this mother of all parliaments, surely we are nothing if we don't uphold our own constitutional practices in the appropriate way. The Privileges Committee will also want to consider the question of compliance with the motion in its full constitutional and historical context. The Government would strongly welcome the committee having the opportunity to consider the more general scope of the motion for the humble address procedure, in particular as regards confidential information and the national interest. The committee could consider these complex matters in a full and impartial way, away from the heat of the present debate and in fulfilment of their parliamentary duty as established by this House. And I'm grateful to the Honourable Lady, the Chair of the committee, for the conversation she and I had today, where she agreed that her committee would be happy to consider that. The members of the committee are accustomed to the consideration of complex and contested issues. That is the very essence of their role. Although it would be for the House itself to reach a final determination on whether a contempt has been committed, it should do so on the basis of that full and impartial consideration of the facts by the Committee of Privileges. Therefore, I appeal to all of those honourable members right across this House that if they seek to pass this motion, they should refer it to the committee in line with our parliamentary procedures. And I urge all honourable members to support the government's amendment.
Order. The original question was as on the order paper. Since when the amendment has been proposed as on the order paper, the question is that the amendment be made. Sir William Cash.
Thank you, Mr. Speaker. I must say that I found the answers given by the Attorney-General yesterday extremely difficult to understand in the terms in which they were expressed relating to the national interest, when of course that is a question which is contained in the results of the referendum and the Withdrawal Act of 2018. I also found it very difficult on reports that I've heard that it's most unsatisfactory for this issue to be regarded as a parlour game, that we were told to stop messing around with the process. I have to say, and to grow up, I have to say that I do think that that somewhat underestimated the significance of what we are here dealing with. But I will leave it at that, because people in those circumstances do use language which sometimes perhaps underestimates the importance of the matters that are being dealt with. On the question of conventions, I would simply like to say to the Leader of the House, and indeed to the law officers, that the question of conventions does turn on the reason for the rule. Now, in this particular context, I would simply say that the reason for the application of this particular convention, which includes the question of the ministerial code, which I shall come on to in a moment, quite clearly demonstrates that unless you know what the Attorney General has actually given by way of a full disclosure, it is extremely difficult to know whether or not the public policy which has been pursued is consistent with the legal advice that he gave. Ivor Jennings is one of the greatest constitutional authorities on these matters, also says that conventions are observed because of the political difficulties that arise if they are not. I would suggest that nothing could better illustrate the current situation, and in particular the issues which I am about to deal with relating to the ministerial code itself. Under the ministerial code, it is essential that the law officers are consulted in good time before the government is committed, and I use the expression set out in the code, to critical decisions involving legal considerations. Now, I've been informed, because the Chequers proposals lies at the heart of the beginnings of the issues with which we're considering the withdrawal agreement, that the law officers were not consulted before the Chequers proposals, with dire consequences, including, as I said to the Prime Minister on the 9th of July, that I didn't think she would be able to reconcile the Chequers proposals with the express repeal of the European Communities Act 1972 in the 2018 Withdrawal Act. Now, this was passed on the 26th of June. 16 days passed, and then we were presented with the Chequers proposals. So everybody knew when the Royal Assent was given that the express repeal of the 1972 Act had actually been enacted, and yet it was quite clear, because it was only a few days later, that a white paper of 80 pages was produced, the effect of which was to demonstrate that the 1972 Act was going to be considerably altered. And therefore, I regarded that as a massive breach of trust, which could have been resolved if we had the full advice of the Attorney General at that time, at that moment. Now, under the same convention, and with respect to this present withdrawal agreement, it is essential for us to know now whether the present Attorney General gave advice on the issue of incompatibility between the expressed repeal of that 1972 Act in the Withdrawal Act itself and the withdrawal agreement itself. Now, in the introduction that he gave to his legal statement yesterday, there is no indication that he addressed that question as a matter of fundamental constitutional importance. Indeed, it does state that the agreement needs a new Act of Parliament in domestic law, but as I pointed out in the Sunday Telegraph, this is no more than a wing and a prayer. I asked the Prime Minister about these matters during her statement last Monday, and also in the liaison committee, to which I received no satisfactory answers. I also asked the Attorney General yesterday a similar question, and I asked him to draw his own attention to a Queen's Bench division which was cited as a precedent for the disclosure of the Attorney General's advice. There are 4 other precedents, but factor tame is particularly significant because of the incompatibility between the 1972 Act and the withdrawal agreement. So what I'd say to you, Mr. Speaker, is simply this. that if we do not have the full disclosure of the opinion of the Attorney-General, this is relevant to the question of whether or not the actual withdrawal agreement itself is invalid under the Vienna Convention, because a fundamental failure to comply with internal domestic constitutional law does amount to grounds for the invalidity of such a withdrawal agreement. And I would simply say, just one moment, I would simply say this, that if there is a danger of invalidity of that withdrawal agreement, this is a matter of fundamental importance on which I would have expected the Attorney-General to include his opinion in relation to this withdrawal agreement. But there is no evidence whatsoever that he has referred to that in his opinion, and that is why we need to have its full disclosure. I also understand that there are, from within governmental circles, that there are sheaves of papers unpacking the repeal of the 1972 Act with respect to the prospective withdrawal and implementation bill, which again is a matter of extreme public importance. By any standards, all these matters fall not only within the ministerial code, but also within what I would have hoped and expected the Attorney-General would deal with in relation to his opinion and the statements he gave yesterday, but there was nothing there to give me any comfort whatsoever. So I do think that to say that we should move on and that we should get real and that what he thought was in the national interest does also bear on the question of whether, in fact, the Withdrawal Act of 2018 is not a matter of extreme public interest and fundamental importance. And the failure to address that question in the introduction and in the legal statement does seem to me to be a mistake of the first order, and furthermore to be inconsistent with what I would have expected from the legal opinion of the Attorney-General. Could I just add this? As to the role of the Attorney-General, I simply refer to the authoritative work, The Attorney-General, Politics and the Public Interest, published in 1984 and written by Professor John Edwards. In his chapter dealing with ministerial consultations with the law officers, it is made clear that all the legal advisers from all departments in the whole of government ultimately will turn on the view of the Attorney-General. As he states, there will be times when the department's proposed, when the Attorney-General, perceiving the legal implications of a department's proposed course of action, in this case number 10 and the Department of DEXU, will find it necessary to oppose himself a minister's preferred policy. And such opposition must also derive from the legal implications of the proposed policy. For the government, he says in this authoritative work, to reject such advice would be quite exceptional and would reasonably lead to serious questioning by the Attorney-General himself of his continuing to serve as the government's chief legal advisor. That appears on page 190. Without full public disclosure of his opinion, it will be impossible to get to the bottom of all these considerations, which are at the heart of the issue of public trust, to which the Secretary of State referred regarding the manifesto of 1985 and the reasons for his resignation, and the conduct of the government, to which I have referred myself in terms of broken promises by the government in the House recently. I would simply add that the reason why my European Scrutiny Committee is making a full inquiry into this, in a nutshell, is this: that we want to get to the bottom of the conduct and the processes and the outcome of these negotiations, and we will do so by taking evidence, and I trust that the government will take note of the seriousness of the suggestions and the arguments that I'm putting forward, because they go to the heart of public trust, the referendum vote itself, the repeal of the 1972 Act, and also whether or not the Attorney-General has fully addressed, in an opinion to which we have a right, in my opinion, to see, the consequences for the withdrawal agreement of the opinion that he has given, and the question of whether or not it is really in the public interest for it not to be disclosed.
Thank you, Mr Speaker. Can I start by commending those honourable and right honourable members who have secured this debate and thanking you for allowing it. Can I also pay tribute to the stamina of my honourable friend from North East Fife and others of my colleagues who last night assured that you would have ample time to consider the response to the original application. Mr Speaker, later today, we begin 5 days of debate on possibly the most important peacetime decision this Parliament will ever take. Today also, Ofsted has described the government's treatment of thousands of vulnerable school children in England as a national scandal. We have a major investigation into the alleged profiteering with funeral companies. We've had reports from a UN Special Rapporteur and the Joseph Rowntree Foundation highlighting the appalling poverty that exists in this, one of the wealthiest economies in the world. What's that got to do with the motion before us just now, Mr Speaker? Because the only reason that we are allowed to discuss those things openly and without fear, indeed the only reason we're allowed to know most of those things, is because the power of the state to stop us from knowing is tempered by the rights of a democratically elected Parliament. Not tempered nearly enough, in my humble opinion. The Parliament is not democratically enough elected, in my humble opinion. But we do have an elected Parliament to hold back on the excesses of the state, to hold back on the excesses of the government. And that is what today's motion is all about. A Parliament of 650 people, each one of us entrusted to exercise sovereignty on behalf of those who sent us here. A contempt to this Parliament is a contempt for the fundamental principle of the sovereignty of the people. A contempt to this Parliament is a contempt for the people. A government that seeks to place itself above the express will of this Parliament is a government in contempt to the people, and it is a government that has already taken a dangerous step down the road from democracy towards dictatorship. And today's debate is not about the rights and wrongs of the original motion as presented to the House on the 13th of November, because astonishingly enough, the time for debate on those questions was the 13th of November. So let's not spend time today on questions of convention and precedence, of confidentiality of legal advice, and of when that confidentiality should be waived. The time for that debate has gone. The time for opposition to the terms of that motion was when you, Mr Speaker, called the question. And at that point, the government instructed its members to do nothing. The government instructed its members not to oppose that motion. I welcome the degree of humility they're shown in now admitting that they got it wrong. But the government having got it wrong is not an excuse for the government unilaterally to seek to change the wording or the meaning behind a decision, a binding decision that has been made by this Parliament. The government seem to decide that they can change that meaning. They've got the audacity to come back here yesterday and today and tell Parliament that they, and not Parliament, know what it was that Parliament decided and know what it was that Parliament meant when they took that decision. Mr Speaker, they are placing themselves above Parliament. They are placing themselves in contempt of Parliament. And as for the legal position document published yesterday that was going to fix it all, that could hardly have been more patronising if they'd had pictures to colour in and rejoin the dots puzzles every so often just to keep us interested. It was not a legal position by any accepted definition of those terms. It was an attempted sop, possibly at some of their own MPs, who I know are in a very difficult position just now, struggling between their understandable loyalty to the government, to the party, to individual ministers, and their overriding loyalty to the people and to this Parliament. And as the right honourable member for Holborn St Pancras has pointed out, the government have made a habit of not turning up if they think they're going to lose. Maybe the problem is they get so used to being allowed to ignore the views and the opinions of Parliament, they forgot that sometimes Parliament takes decisions that they are not allowed to ignore. Maybe that's why they're so upset now. Maybe it's because alongside the issues about what and should not be made available to members of Parliament or to the public, maybe it's because this decision has laid bare the incompetence at the heart of a government that doesn't even know the basics of parliamentary procedure. I'll give way here.
I thank the honourable gentleman for giving way, and I'm just wondering if this commitment to openness now means that he will be asking the Scottish legal officer to publish all of her advice in the Scottish Parliament in future?
Yes, because
and the relevance of that in this debate.
Mr. Speaker, I have absolutely no doubt that if the Parliament that represents the sovereign people of Scotland gives a binding direction to the elected government of Scotland, the elected government of Scotland will comply with that binding direction. No such binding direction has been given. But let's not, Mr. Speaker, let's not try to deflect attention from the clear and blatant contempt that has been committed against this House with completely false accusations of contempt elsewhere. Mr. Speaker, we have a government who are behaving like a football team that doesn't turn up for friendlies if they think they're going to get beat. And then they discover they've missed a cup final and they've forfeited the tie with a notional 3-0 score. They're now back here not only being asked to be allowed to replay the final, but they're complaining that the score's void because the 3 notional goals would all have been offside if there had been anybody there to defend them. But Mr. Speaker, we're not talking about a game of football with trophies at stake. We're not talking about the sanctity or non-sanctity of the confidentiality of legal advice. We're talking about the most fundamental principle. We're talking about the most fundamental principle that governs our nations. The principle that Parliament can tell the government what to do, not the other way around. And this is not just some temporary individual aberration. It's part of a pattern of government attempts to keep Parliament out of this altogether, restoring sovereignty to Parliament by keeping Parliament out of its own sovereignty. They went to the Supreme Court to stop us having any say on the triggering of Article 50, and they lost. They did their damnedest in here to stop Parliament having any say in the withdrawal agreement, and they lost. They spent thousands of pounds of our money trying to stop a group of Scottish parliamentarians from finding out whether or not Article 50 can be unilaterally revoked, and they lost. The European Court almost certainly now will find that it can be. And I want to pay tribute to the parliamentarians from 5 political parties and 3 national parliaments who brought that decision to the court. I believe that what they have won will prove to be a pivotal victory. But it does raise a question that's too important to be treated as rhetorical, and it raises a question that's highly pertinent to the substance of today's debate. What kind of government goes to court to stop its own citizens from knowing that the government has legal powers but has chosen not to use them? What legitimate reason can there be for a government to want its people to believe that something is legally impossible when the government has already got its own legal advice telling them that it is perfectly possible? Mr. Speaker, I refer to this morning's preliminary opinion from the Court of Justice of the EU as simply another example of this government's attitude that the path chosen usually unilaterally by the government is the only one worthy of consideration, and that nobody is even allowed to know that other paths might be possible. They've got their priorities completely wrong, Mr. Speaker. They repeatedly tell us, and the Leader of the House said often enough again in her comments, that their ultimate duty is to act in the public interest. But in fact, we have a government that demands that Parliament and the public act at all times in the government's interests, and that is not the same thing at all. The government has taken on itself the right to decide what's in the public interest, not the Parliament that holds sovereignty on behalf of the public. The government declares itself to know better than Parliament what is in the public interest. The government places itself above the decisions of Parliament. Mr. Speaker, the government places itself in contempt of Parliament. Early next year, we'll see the 370th anniversary of the day when a Crown King of Scots was executed just a few hundred yards up the road from here for defying the will, not of this Parliament, because this Parliament didn't exist then, but of one of its predecessors. Now, I don't think anyone's suggesting a similar fate for those who are found in contempt of this Parliament, but we should be under no illusions about the gravity of what we're discussing. And we should be under no illusions as to how the mockery from the Conservative benches is being perceived by those who believe that this Parliament should actually be allowed to tell the government what to do. The elected parliaments of our 4 nations, for all the faults and the flaws and the imperfections and the ridiculously outdated procedures and the arcane procedures that the Leader of the House sometimes doesn't like, representing the rights of our citizens. No one has the right to wield power over the people without the consent of the people. In a parliamentary democracy, that consent is expressed through Parliament, not through the office of the Prime Minister or any other holder of the offices of state. When Parliament speaks, it speaks on behalf of the people, and the government must listen. And when Parliament instructs on behalf of the people, and the government must comply. Mr. Speaker, Parliament has spoken. The government must listen. Parliament has instructed. It has not asked, it has not opined, it has not suggested, it has instructed. The government can disagree or moan or complain as much as they like, but they must comply with that instruction of Parliament. Instead, the government seeks to defy the instruction of Parliament. They seek to defy the sovereignty of the people as expressed through their elected representatives. And it is now, Mr. Speaker, for Parliament to take the only course of action open to us, to compel the government to back down.
Nadine Dorries.
Thank you, Mr. Speaker. And I'll just make my apologies before I start that I do have to leave to chair the Finance Bill, and so I do have to absent the chamber quickly. I just want to begin my points, which I will make very short, by referring to the Right Honourable Member for Carl Shulton and Wallington, the Right Honourable Member, and comments that he made on the radio this morning when he discussed the Iraq War debate and the legal advice that was issued and what is happening now, and actually conflated the two, because of course the advice that was issued wrongly by the previous administration, which actually resulted in members in this House going into the lobbies misinformed and without the required information, was about the legalities of the Iraq War, whereas this, as the Attorney-General made clear yesterday, is a political decision, not a legal. No, I'm not going to give way because I have to go. I haven't got time. Sorry. Obviously, yeah. But
thank her for giving way. She's very generous. Can I just point out to her the only point I was making? The comparison was about the risk of cherry-picking. And I don't think anyone would argue that the Iraq War and the position that was set out by Lord Goldsmith actually cherry-picked that advice to maximise the government's position and to press its case.
I do believe that the two issues were conflated, and that this was used as a basis to argue that for the revealing of the legal information now on a wrong predication. I would just like to make that point. I'd also like to go on next to my point about the civil servants and the legal advice that the government receives. You know, Mr. Speaker, I have been in a quandary about this and about this vote today. I would like to see the full legal evidence, as I'm sure everybody in the House would. But there are conventions and also other people to consider, and civil servants fall into that category. They serve us all with true independence, absolute independence. And I don't know where any government ever would be in this place if we could not depend absolutely on the impartiality that we received, of the legal advice that we received from those civil servants. And if this motion is passed today, if this amendment passes today, what civil servant, what legal adviser would ever want to advise any government in the future without first putting in place a filter of self-preservation, of considering that advice that they gave? Who would want to do that as a civil servant? And I think, although I would love to see this legal advice, we have a duty to consider others, the people who serve both the public and us. I actually have 100% respect for civil servants. They work amazingly hard. They are truly independent. They serve us without any political bias, and I think that is something which should absolutely be considered. In terms of the public interest and the points the Attorney-General made yesterday, you know, none of us know if there are any issues, apart from the Attorney-General and the select few, none of us know if there are any issues in that legal advice which pertain to national intelligence, national security, or any other of those issues. And I only have to assume that when the Attorney-General spoke yesterday about public interest, he was talking in the much broader context. And And you know, Mr. Speaker, this is an important issue because in the course of law, and I think I'll just quote the Attorney General yesterday, there is no procedure by which this House can have redactions or entertain circumstances in which it could weigh the competing public interest against the interest of disclosure as a judge would do. Yes. Now, given what happened with the publication of the summary of the legal advice during the Iraq War, This inevitability that's happening today should have been foreseen then, because we live in a changing world. We live in a world where people demand transparency, where they have a right to know all the full information. Mr. Speaker, I believe that a resolution should have been passed in this House to give powers to this House, because after all, Parliament is a court, to give powers and a process in this House whereby this House, probably via your office, Mr. Speaker, through the authority of your office, via the clerks, via independent judicial advice, should be able to take a decision and redact matters of national intelligence and security from legal advice so that people in this House can see legal advice. And I hope that as a result of what's happened today, and given that it will happen again in the future, the demands to see legal advice, that the House will now take some cognizance of this and decide to pass a resolution that will ensure that we don't find ourselves in this position again. Also, I'd just like to go on and say, Mr. Speaker, that we have been told the worst as far as I'm concerned. The Attorney General pulled no punches. When he said there's nothing to see here, actually he told us what needed to be seen, and for me, I'll again quote his words. There is therefore no unilateral right for either party to terminate this agreement. This means that if no superseding agreement can be reached within the implementation period, the protocol would be activated and international law would subsist if negotiations are broken down. He told us the worst. We will be in the backstop in perpetuity. That was as bad as it gets. If we cannot withdraw from the backstop following the decision of this House, we are trapped, as somebody said, from a sedentary position yesterday. And I believe that no MP with any conscience, given with what the Attorney General told us yesterday, could actually vote for the withdrawal agreement because he pulled no punches. He told us the worst it can actually be. And I commend him for that. And I want to finish, because I have to, with with a comment about us. You know, I listened to the Right Honourable and Learned Gentleman for Holborn and St Pancras when he said those words at the dispatch box. And one day, and I hope he's white in hair and long in tooth before he gets there, but he may be the Attorney General. And his words may come back to haunt him at some time in the future. And I could see, I have watched him many times, and I could see that thought going through his eyes. As a legal advisor, formerly, to one of the most eminent law firms in the country, he knows full well, when he stands at that dispatch box, what he is saying and what he is doing. And I hope you never find yourself in the position that you have put our Attorney General in. And I would like to finish, Mr. Speaker, with this.
I can't quite understand why the honourable lady thinks that someone of my limited capabilities aspires to the high office of Attorney General. Nadine Dorries.
Absolutely, Mr. Becker. Mr. Speaker. And I should know better. I should know better. I apologise. I would like to finish with this, that we are all, before we are Attorney Generals, before we are Mr. Speakers, before we are French bench spokesmen, we are all MPs, we are all elected members. And I believe that both the Attorney General came to this dispatch box yesterday in both honour and in good faith and was honest. And the result of what will happen today, if this amendment is passed, that the integrity and the reputation and the honour of a good man will be traduced. And that will be a disgrace of this House to do that, because any one of us may one day be in that position. And God hope that it does not pass today for that reason.
Mr. Nigel Dodds.
Thank you very much indeed, Mr. Speaker. And it's a pleasure to follow the Honourable Lady, the member for Mid Bedfordshire. And I don't agree with the main thrust of what she said, but she did make some very, very useful and pertinent comments about what the Attorney-General said yesterday in terms of the analysis of where we find ourselves. I agree with her and other honourable and right honourable members who have praised the Attorney-General and his candour and his honour and what he has brought to this House yesterday in terms of more truthfulness, if I can say, about what this deal actually means, in contrast to others who have been prepared to say things to the press and media. He came here as a member of the Cabinet and told us some of the unvarnished truth about this agreement. So I do praise him for that and join with the Honourable Lady in what she has said, because when I went through the adjectives that he used in his devastating commentary yesterday about this deal being a calculated risk, unattractive, unsatisfactory, undesirable, that it did provide no unilateral exit clause for the United Kingdom, it was indefinite, no unilateral right to terminate. But he asked us to take it on trust that it would all never happen because, believe it or not, having spent 18 months negotiating all of this, the EU and the Irish government don't actually want to implement any of it. The fact is, Mr. Speaker, that despite all of the candour and all of what was said yesterday, the coming to this House and making, yes, 2.5 hours of an oral statement and taking all the questions and providing the reasoned position paper does not actually fulfil the order, the motion that was passed by this House, which was for the final and full advice provided by the Attorney-General to the Cabinet to be published. Now, the Government may not like the fact that this was passed by this House, but it cannot simply wish it otherwise. During the course of the debate on the 13th of November, it argued that it would do precisely what it has now done. That was rejected by the House. The House passed a different motion. And it is not good enough now for ministers, and it's not particularly the Attorney-General we single out, because he said himself in the statement yesterday that he wished that he wasn't in the position that he was in. But it is the government as a whole which is collectively responsible for deciding that it will simply ignore this binding effective motion and revert to doing what it said it would do during the debate. Well, quite frankly, Mr. Speaker, that cannot be allowed to stand. We've heard a lot of talk about precedent and about conventions of this House and respect for all of that. Well, surely this is one area where the government must respect the will of Parliament and simply cannot set it aside. The Father of the House, in his intervention earlier, made a very interesting and I think a positive contribution about a way round this. But it's interesting that the government didn't take that up. It didn't take it up during the course of this debate, and it hasn't taken it up previously. So clearly the government isn't interested, it appears, certainly hasn't said anything publicly up to now, about taking that suggestion forward. What it has done is say, no, it doesn't matter what is said by this House, doesn't matter what other suggestions are out there, we are going to stick to the plan. They obviously have a grid somewhere where this is on the plan, that they will publish this reasoned summary position paper and have a statement, and that is it. Mr. Speaker, this House will have the final say, and I hope that it will reiterate what it has previously ordered on the 13th of November to be done. Now, we're told that this is unprecedented. There are, of course, it was said in the other place yesterday, that in exceptional circumstances, advice like this can be published. I've also heard the argument used that this is privileged. But, of course, privilege in the lawyer-client relationship belongs to the client, not the lawyer, not the person given the advice. The lawyer has a duty to protect the client's privilege, but the reality is that if the client waives that, then the lawyer, the provider of the advice, is quite at liberty to disclose. So this argument about privilege is a bogus argument. The Attorney-General says that he would wish to comply. The Attorney General said yesterday, and the Leader of the House, I wish I could comply with the order of the House, but it's not in the national interest, not in the public interest. I'm afraid it's not the duty or the job of any government minister to decide that. The House has decided what it wishes to do, and it's not for a government minister to unilaterally override that with no good reason. I give way to the honourable gentleman.
The right honourable gentleman is very kind to give way. He's a patriot, and I know that he therefore understands national security and the national interest. Would he agree with me, however, that quite probably within the legal advice that the Attorney-General gave to the government would have been an analysis of the strengths and weaknesses of the Irish government's position? And does he agree that to publish that in full would actually hand to the Irish government an advantage in any subsequent negotiation?
I'm tempted to say to the honourable gentleman, I think the massive advantage to the Irish government and other governments and to the European Commission is handed over in this withdrawal agreement in terms of future leverage over the negotiations. But I don't accept what he says, because the Attorney General went on record yesterday as saying that there was nothing to see. Nothing to see here, so there obviously is nothing of concern about national security in this. That's what he said himself. So I don't accept what he has said. The reality is, Mr. Speaker, that had the government, this debate was had on the 13th of November. That's right. The government had the choice to vote against and decided not to vote against because they feared that they would lose the vote. And it cannot be the case, that by abstaining from a vote on a humble address, that invalidates the motion, because that would be a very, very serious precedent to set indeed. So, Mr. Speaker, we have had the situation where some of this legal advice, as given by the Attorney to the Cabinet, and it's that advice that is crucial that we must have, has already been leaked by members of the Cabinet to the press and media. And the Attorney General, I think, accepts that.
He shrugs his shoulders.
So the reality is that members of the Cabinet have already released some of this advice given by the Attorney in terms to the Cabinet to members of the press and media. I think that the Attorney is somewhat stopped, if I may use a legal phrase, from saying that the rest of us, therefore, are not entitled to have that. I think if some members of the select media and press are entitled, then I think the members of this House are entitled to have this advice. I'll give way to my honourable friend.
Will you remember agree with me as well that if the government and the Prime Minister is going around the country trying to convince the populace that this is a good deal, that this approach, this secret approach, only confirms in people's minds that there is something to hide. And in fact, if anything, the government is scoring an own goal by refusing to publish this advice.
I thank my right honourable friend, and indeed that very point about the government actually scoring a massive own goal in its own terms has been made not from these benches but by a former cabinet minister on their own side and by many honourable members on the government benches. So the right honourable member sums it up very well. What is there to hide, given that the Attorney has said there's nothing to see, given the fact that we have the clear motion passed in terms by this House? It is absolutely vital now that that is enforced and the bogus arguments against it are rejected.
Thank you. Mr. Dominic Grieve.
Well, thank you, Mr. Speaker. Mr. Speaker, I'm not sure that members of the public coming in to watch our debates would necessarily appreciate our role as the High Court of Parliament, but that is what we are. And by virtue of history, we've been given a whole range of powers enjoyed normally only by others of Her Majesty's courts, by which we both regulate our affairs, maintain our own privilege, which also means by virtue of the Bill of Rights of 1689 that we can't be impugned in any other court, and have coercive powers for dealing with those who transgress in front of us. And that can include government ministers. The difficulty we have, I have to say, from having served on the Standards and Privileges Committee and also been a law officer, is that our powers are entirely archaic, almost completely unusable, and in many cases are so old-fashioned and antiquated that any attempt at using them would probably run foul of most modern principles of justice. And I'm afraid that this situation has been allowed to prevail for decade after decade by a mixture of a failure of the House to grip the problems it faces and, of course, the happy complacence of government that has known that in reality the teeth are not really present for this House to assert its authority. And nowhere do we see this come to a head more than with this issue. It's all very well criticising the Right Honourable Gentleman, the member for Holborn and St Pancras, that the instrument he's used is a blunt one, but there are only blunt instruments to be used. And he was fully entitled to table the motion he did and to seek from the government the documents that he wanted. And the government chose, I have to say slightly to my surprise, Mr Speaker, not even to oppose the motion, even though there were compelling arguments that could be presented, and indeed I can continue to be of that view, that the law officer's advice should not be published because it undermines the ability to provide proper confidential advice to government. That said, Mr Speaker, the method that was adopted, and it may simply have been because of the speed with which the drafting took place, was undoubtedly very blunt. Given its ordinary meaning, the humble address, as I interpret it, extends not just to the Attorney-General's advice, but to every advice that was provided to government during the course of the 2.5 years of tortuous negotiations with the EU, provided through the civil service at any time about the development and impact of the withdrawal agreement. I have no doubt that most of that is unlikely to be of great relevance to what the House wanted to see, and, moreover, some of it may undoubtedly contain confidential material which, if put in the public domain, could well jeopardise the national interest. When I don't suppose, just to take an example, that this House would seriously contemplate requiring the government, for example, to disclose the name of agents working for MI5 or MI6. But you have to face the fact that this House does have the coercive power to make such a request. And this highlights the untrammelled nature of its sovereignty, but also the extent to which it can be open to abuse. In fact, during the course of the debate, the Right Honourable and Learned Gentleman, the member for Holborn and St Pancras, I think became aware that the terms of the motion were rather widely cast, because he restricted them at that point to seeking the final and full advice by the Attorney-General to the Cabinet concerning the terms of any withdrawal agreement. I simply make this point. Having been a law officer and supplied advice to government, it may surprise the House a little, but I've simply no idea if there ever was a final and full advice of the kind that was identified, because in my experience, the advice provided by law officers comes in a continuous stream of dribs and drabs, which by letter to the relevant department and to the Prime Minister, and if necessary to the Cabinet, touches on a multiplicity of things without necessarily being drawn into a whole. So I have to say that what is being sought here is about as easy to measure as the length of a piece of string. It is not at all clear what it is that the motion is seeking to grab onto, although I do accept that insofar as the motion is seeking to acquire the original documents of some of the advice that was provided, it is manifestly clear that it has not been complied with. That is apparent. Now, faced with that problem, where should the House go? Of course, within this House, there are going to be differences of view. The government wishes to protect its position, and the Right Honourable Gentleman and all those on the opposition benches, and indeed some on my own benches, who wish either to embarrass the government or just want to see this information, are going to be profoundly dissatisfied. The question of the culpability of ministers is in any case not uniform. If I say this in defence of my Right Honourable and learned friend, the Attorney-General, he is not a member of the Cabinet, although he attends Cabinet, and as the point has been made, he's covered by legal and professional privilege about disclosing the advice he provides to his client. The one person who cannot be blamed for this mess is him. He came along to provide as best an explanation as he could yesterday, but the fact is he is not responsible for making the decision as to whether the documents that the House wants are disclosed. I assume that may have been a collective decision of the Cabinet, although knowing the way the Cabinet works, I'm not even sure that that's necessarily the case. It may be an individual minister, or it may indeed be my right honourable friend, the Prime Minister. But whichever it is, this also emphasises the blunt nature of the instrument, which is then reflected in the motion that has been brought before the House today. Now, it may be seen to be getting the government a little off the hook, but referring this to the Committee of Privileges is not a stupid course of action. I'm afraid I can anticipate a little how it's likely to progress, because the Committee of Privileges in its session will immediately come to the awareness of just how complex and bedeviling this entire area is because of the lack of clarity of both our standing orders and the processes of this House. But to simply go ahead without doing that and to move to a statement of contempt, and I'm not quite sure, and it hasn't really been explained, where, if that is passed, we proceed next, does seem to me, on balance, and I say on balance because I have sympathy for the position of the Right Honourable Learned Gentleman, the member for Holborn and St Pancras, on balance seems to me to be the better course of action. But I acknowledge that on the face of it, we have processes in this House, and if this House is to work properly, they ought to be capable of being met. But what this highlights over and over again for me, and has done for many years since I came in here, but particularly since I became after I was a law officer, is that our processes and powers bear no relation to the real world in which we have to operate, and that as a consequence, they can cause serious injustice. And that is something which all of us should be very careful about preventing.
Mr. Tom Brake. Speaker, could I first of all start by perhaps praising the Attorney-General for spending over 2 hours answering questions, but could I perhaps gently also chide him for the manner in which occasionally his style of delivery descended rather into vaudeville. Finger-pointing, faux bonhomie and expansive arm gestures may work in court, but perhaps he might like to leave those at the bar of the House. Now, the Leader of the House referred to an arcane procedure, and others on the other side have referred to us on this side playing parlour games. Now, the arcane procedures and the parlour games that the honourable members opposite are referring to are about holding the government to account on a matter of contempt. So arcane they might be, but clearly they are essential as well. And members will know that Parliament's Bible, Erskine May, makes it very, very clear that the government's actions are in contempt. Their refusal to release the advice is an act which impedes the House in the performance of its functions. And what could be a more important function for this House than to have the full legal advice on Brexit, so that in the decisions we are going to take in the next week or so, we are able to take those in the full knowledge of the impact of Brexit. And that is why we are here today. And that is why, Mr. Speaker, I wrote to you on the 28th of November and subsequently signed the joint letter raising this issue of contempt. Now, the government came forward with a reasoned position paper, and I think the member for Beaconsfield did a good job of explaining quite how complex and extensive the legal advice is that the Attorney-General will have received. But I suppose that rather did reinforce the point that the Attorney-General producing a synopsis of said extensive legal advice spread over much correspondence does run the risk of perhaps presenting that synopsis in a way that is most advantageous to the government. And in relation to the intervention from the Honourable Lady, member for Mid-Bedfordshire, who is no longer in her place, the only point I was making again, and I'm very happy to get it on the record again, in relation to the advice about the Iraq War, is that clearly that was advice that was cherry-picked, massaged and presented in a way that reinforced the government's case. And that is the only comparison that I'm making, with a possible risk of the government unintentionally perhaps doing exactly the same thing in relation to the full legal advice that ministers have seen, and indeed ministers have leaked. And while a reference was made to that, I think the Attorney-General simply shrugged his shoulders, as if leaking that advice selectively to the media from the government is something that is perfectly normal and acceptable in the daily course of government business. So we know what happened in relation to that advice about the Iraq War. And as for the government's amendment, we know clearly what the purpose of this is. Even with undue alacrity, the prospect of the Privileges Committee addressing this before the 11th of December is precisely nil. So in terms of us having clarity and guidance and a direction to the government, we're clearly not going to get that before the 11th of December. And I must say that I suspect that is what the government's motivation is for pushing that particular amendment. And of course, this is a pattern of government unwillingness to allow members of Parliament to have access to the legal advice that we need to take the decisions that we need to take here. And the Article 50 case is a very good example of that, where the government have repeatedly refused to say whether Article 50 is revocable, hiding behind the fact that they're not going to seek to revoke it, so Parliament doesn't need to know. Well, I'm very pleased that the Advocate-General today has given a recommendation. It is only a recommendation, the one that is very likely to be adopted by the Court, that makes it very clear that Article 50 is revocable. And for members of Parliament here, who next week are going to be taking votes where it is critical for us to know whether that is the case, in other words, if a people's vote is secured and at the end of that campaign people vote to stay in the European Union, we have a means of revoking Article 50 to bring that into effect. Very happy to give way.
On that point, does the honourable member believe that the Attorney-General gave advice to the government on the revocability of Article 50 and has hidden that advice from this House? And that is why we haven't had that disclosure.
All we know for a fact is that a number of members of Parliament, including, I suspect, the honourable gentleman, have repeatedly asked the government to confirm what their position on that is, and they've not been willing to do so. And that's why I think on these benches we very much welcome the fact the European Court will resolve this matter in the next couple of weeks. Just on that issue of Article 50, I did want to thank the member for Edinburgh South West for leading that charge, along with other members of the Scottish Parliament, and indeed also the member for Nottingham East, who is not, I think, in his place today, who has joined me in perhaps a supporting cast role in relation to the leading role that the honourable member for Edinburgh South West played in relation to that case. But, Mr. Speaker, I'm very happy to give way.
Can I just say to the honourable member, I'm really pleased that he and my friend from Nottingham and the member for Edinburgh took the risk of taking this case to the court to establish an important principle, and that if the decision now is in line with the advice that is being given, then I think that is in the interests of the democracy of this country, and I think we should register our thanks to him and the other members.
Thank you for registering the thanks for me. I thank the honourable gentleman for that. But I think the critical point, for instance, for members of Parliament here to know is that, for instance, if we go beyond the 21st of January without a deal, and we start going down the track of no deal, that it is open to this House, it is open to this government to revoke Article 50 to avoid a catastrophic exit from the European Union. Knowing that is something which I would argue, and many members on this side have argued, we are entitled to know and it's remiss of the government to have kept that information from us. But just to conclude, Mr. Speaker, I knew that would cause a celebration on the opposition benches, so for that I will speak for a little bit longer than I had intended. Mr. Speaker, I accept that this is not a simple choice that members have to make today. I accept that. Publishing the full legal advice has serious implications. Of course, I accept that, and I think everyone on these benches accept that. But the ramifications of the government ignoring the express demand of Parliament are of an even greater import, and that is why I urge members to vote for the motion today.
Mr. Jacob Rees-Mogg.
Mr. Speaker, I think we need to start with why parliamentary privilege is so important, particularly those of us on the government side, because there will come a time when we are not on the government side, at which point the protections provided for us by parliamentary privilege are all the more important, and that governments who run roughshod over parliamentary privilege when they are in government find that when they are in opposition, their position is much harder to defend and uphold. When the Conservatives were in opposition, we disliked the streamlining of parliamentary procedures that made it easier for the then government to get legislation through, because we found it harder to have the full debates, the full discussion that we wanted, the ability to discuss and sometimes even delay things which we were deeply opposed to. And that was a loss to us in opposition, even though a benefit once we were back in government. And my right honourable friend, the Lord President of the Council, mocked the humble address procedure on the basis that it was ancient. But every morning when we come into this House, when we pass through security, we are exercising a right that dates back to 1340. Whether you have your pass on you or not, you are entitled to come into this House, and nobody is entitled to obstruct you. And this is an important right because in times less benign than ours, people have wanted to obstruct members coming into Parliament. And we sit in a House where there is a very slim margin. And it may be that rushing back for a division, perhaps a division of confidence in the government, somebody obstructs you coming in, but that would be a breach of your privilege, and though it is very ancient, one of our most ancient privileges, it is actually a great safeguard of the proper democratic operation of this House. And we heard from the Treasury bench and from other right honourable members a very good argument for why the humble address should not have been passed in the first place. But today is the wrong day for that debate. That debate should have been held on the 13th of November and voted on or not, according to whether or not it were the will of this House for the humble address to go through. And the tradition of humble addresses is very clear, that the humble address is followed. Now, that does not mean that this House is irresponsible in passing humble addresses. We have heard suggestions that we might seek information from the security services. This House has never passed a humble address of such an unwise kind. And though I am not, dare I say, the greatest admirer of the socialists opposite, I accept that they are responsible enough not to wish to endanger the security of our nation. But that Parliament has the power does not mean that Parliament will exercise the power. Indeed, and importantly, this House constrains its right of free speech in relation to the sub judice issue. We have passed standing orders, and we give power to Mr. Speaker to stop honourable and right honourable members breaching the sub judice rule to ensure that the system of justice in this country proceeds properly. Likewise, we are entitled to limit the means of humble addresses and the information that can be received from a humble address. But we did not do so before the 13th of November. And therefore, what happened on the 13th of November ought to be complied with. Because if we simply say that motions of this House, according to great antiquity and precedent, can be ignored because the government feels like it, then what is this House here for? How are we protecting the rights of the people we represent? How are we able to seek redress of grievance? And the fact that it might have been unwise, indeed, had there been a division on the 13th of November, I would have voted against revealing the Attorney General's information and advice to the government. I did not think the humble address was well advised, but the government decided to accept the motion. And having done so, it was not then up to the government to say that it was not in the national interest to do so. I'm afraid that is a classic confusion. The government interest and the national interest are different things. The government interest is a political interest. The national interest is a higher interest. And in my view, the national interest is better served by respecting the privileges of Parliament than the convenience of the law officers. And therefore, in the national interest, not the government interest, this legal advice ought to be produced because Parliament has said so. And this is clearly a right that this House has. Every select committee has the delegated right to send for persons and papers. And this is simply an exercise by the whole House of requiring that papers be produced. But the government, with its majority, perhaps a majority it cannot always achieve, but at least with a technical majority, thanks to our friends in the Democratic Unionist Party, the government, with its majority, ought to be able to stop any papers it believes too confidential from not being produced. And indeed, it is still open to the government to bring forward a motion suggesting that the previous motion be overturned, and there is precedent for overturning an humble address and seeking to do the opposite. So there is a proper process for the government to follow if it does not want to release these papers, rather than sticking its feet in the mud and saying no. So then we come to the motions before us today. And here I agree with my right honourable and learned friend, the member for Beaconsfield, that I don't think the motion before us actually works, because it is too indistinct about who it is criticising, that it is criticising ministers broadly rather than the ones specifically concerned. And I think the motion needed to be more specific on who it was objecting to, who it was holding in contempt, and indeed ought to have used the rights that Parliament had to inflict some punishment on the person who is deemed to be in contempt. Yes, of course, I give way.
I'm grateful to the honourable member for giving way. If he feels as he has described, why didn't he put down an amendment to my right honourable friend's motion, setting out the position as he thinks it ought to have been done?
Well, I'm very grateful to the right honourable lady for her intervention, because the government has put forward an amendment that I feel that I can support, though we're not the pantomime season quite yet. I give in on that one, Mr. Speaker. I am defeated on that particular point, but not on the substantive one. That I am happy to support the government's amendment, because I think it is right that a committee of this House looks at the issue in broad terms, because it may be right that the House wishes to take a self-denying ordinance on the extent of humble addresses. It may be that we would like to say specifically that they would be deemed disorderly and therefore not brought forward if they related to matters concerning the security services or other types of information where there would be a broad consensus that those matters should not be brought forward. Dare I say, the ability to demand papers could require that the tax return of honourable gentlemen and ladies opposite be brought forward to the House. Mine would be of so little interest I can't imagine it happening. But that would be... that would be a clear abuse. That would be a clear abuse of the precedents that we have. So it may well be right that the Privileges Committee should consider broadly how humble addresses should be used to ensure that they are effective, because currently they ought to be effective. The government ought to abide by them. But there is one... Yes, of course I'll give way.
As ever, following his remarks with a great deal of interest, he will know, since he's an expert on Erskine May, that at page 168 from memory, it says very clearly that the humble address should not normally be used on matters that touch directly on bills before Parliament, as this clearly does. So was the humble address being used correctly in his view or incorrectly?
I'm sorry to say that my honourable friend isn't quite right. There is not a bill before Parliament on this issue. There is a motion before Parliament on this issue, and those two are clear separate matters, that they are not to be confused. And I have no doubt, Mr. Speaker, that had an humble address been brought forward on a bill before Parliament, it would have been ruled disorderly and therefore would not have been a subject for debate. And for the benefit of the Hansard reporters, Mr. Speaker is nodding, and therefore I hope this can go into the record as an authoritative reply. There is one concern I have about the reference to the Privileges Committee, and that is, of course, that the Attorney-General is himself a member of that committee, though a non-voting and a non-adding to quorum member of it. And I'll give way to my right honourable friend.
Officers would recuse themselves from any such meeting.
Well, I'm extremely grateful because...
Just speak into the microphone. The vast majority of members haven't got the slightest idea what she was saying.
I'm sincerely sorry, Mr. Speaker. The law officers would recuse themselves from any such meeting.
I'm extremely grateful for that. That gives me complete confidence in supporting the government's amendment. But I would absolutely reiterate that however the vote goes today, the humble address must be obeyed unless overturned, and for the government to fail to do so would not be treating Parliament properly. And on these benches, we must remember the great need for us, when we are in power, to defend the rights of Parliament for those occasions when we will not be.
Thank you. Geraint Davis.
Mr. Speaker, the question before us is whether there is information that was in the legal advice that is relevant and pertinent to the crucial question we must ask ourselves in voting on the withdrawal agreement. And against that, the government has suggested that there's security and national interests to defend that. I put it to you that in the motion before us, it says that we should provide the final and full legal advice provided by the Attorney-General to the Cabinet concerning the EU withdrawal agreement and framework, and that doesn't imply every email and every jot that's required. And certainly it seems to me that in terms of national security and national interest, that isn't a great risk. The question really is there a reason to believe that critical legal advice has been withheld? And I suggest that there is that reason, and I put it to the Attorney-General yesterday, following advice from Council in two chambers, that in essence, the EU Withdrawal Act, in essence, gives the Prime Minister the right to submit Article 50 based on an advisory referendum. But if that referendum has been found to be conducted illegally and subject to cheating and lying, then the advice is flawed, so the notice should be withdrawn, and we've heard from the Advocate General that in all probability it can be withdrawn. Was this advice tendered or discussed by the Attorney General to government? Well, he didn't mention it at all, and yet it is advice that is available. So it suggests to me that, in fact, the advice that has been given to this House is incomplete for us to make those conclusions. In terms of this argument about whether the government now should basically revoke Article 50 on the basis that the advisory referendum was flawed, the argument, in short, is that we already know that the Leave campaign misled the country during the referendum, firstly, either deliberately or not. Secondly, that multiple investigations by the Electoral Commission have found that the Leave campaign broke campaign finance law. Thirdly, that had those offences committed by the Leave campaign been committed in a general or a local election, then that result would have been legally void. Fourthly, that the government has a legal duty to take all relevant considerations into account when making a decision, and therefore the fact that the referendum result would have been void due to one side's illegal conduct in any other election is a relevant consideration when deciding whether to give effect to that result. That is, in ratifying the withdrawal agreement, which will give Brexit effect. In essence, then, the advice on the withdrawal agreement the Attorney-General should have considered would be whether the government was failing in its duty by promoting the agreement when the animating factor of the agreement, the referendum, was so fundamentally compromised. Therefore, the government is there acting illegally by moving forward with Brexit without giving proper consideration to these facts. Now, this whole debate and discussion wasn't included, whether one agrees with it. This is a discussion that would have occurred within the ambit of the Attorney-General that we don't know about. And this is a key reason to believe that the advice being given has been doctored for party political reasons, and we need the full and latest advice. We've just heard that the Advocate General is saying that Article 50 may be revocable. What is the view of the Attorney General given in the legal advice to the government? We haven't been told. I'll take the intervention in a moment. The point I'm trying to make is the Attorney General must be aware of these points of law, and hasn't elicited these points of law, and so we must conclude he's withholding from the House relevant issues, not for the national and public interest, but for party political reasons, and therefore is in contempt of this House. I will take an intervention.
I'm grateful for the honourable gentleman giving way. He makes very serious allegations in what he's just said. Does he not recognise the importance of legal professional privilege and the privilege that attaches between a lawyer as an advisor and their client?
Well, of course I do. And the whole point here is that this House is entitled to the full legal advice. The government is hiding behind this cloak, oh, the national interest, oh, negotiations, oh, security. This is nothing to do with it. What I am illustrating here with these legal arguments is that there are alternative views that need to be fully discussed so that we can take the right decision on the withdrawal agreement in full knowledge of the facts. And what we've had is a doctored version which is politically spun in the interest of the government getting its objectives through. And they're protecting themselves by saying, oh, well, it might be national security, MI5, the public interest, etc., etc. I do have a great support, I must say, for the Father of the House's suggestion that if there were such problems with national security, and that those could be redacted and we can see the full legal advice. And I think this motion, in essence, focuses clearly on the legal advice provided by the Attorney General on the EU withdrawal agreement. And implicit in that, in my interpretation, is that we obviously don't need to have lots of details about MI5, national security, etc., and the negotiating position. What we want to know is what is the legal position in respect of Article 50? What is the legal position in respect of the illegalities during the referendum, making the advisory referendum flawed and therefore undermining the very power that the Prime Minister has under the EU Withdrawal Act, which is based in the advice of the referendum we now find is flawed. None of this is brought towards the House. Why? Either because the Attorney General and his colleagues are incompetent, or that they're withholding that information. I will give way.
I thank the honourable gentleman for giving way. And the point he makes about national interest and public interest, and this government hiding behind that, and also claiming to be the final arbiter of public interest. Would he agree with me that they are not the final arbiter of public interest, despite what some on the opposite benches may think? And when it comes to public interest, is it a case of this UK government governing in secret over the members of this House having all of the information to make a proper and educated decision?
Yes, that's precisely what this House wants is the complete legal arguments on either side of the arguments. These are difficult issues, we all accept that, we're all grown up, on this EU withdrawal agreement. And if it said, oh, well, there's all these things about national interest and negotiation and security, people aren't interested in that. We want the full facts. And I've simply made some simple illegal points that show the full debate has not occurred. Yes, I will.
I'm very grateful to the honourable gentleman for giving way. Is he interested, like I am, in legal advice given to the European Commission and their negotiators by their lawyers, which presumably the European Commission would like to be privileged in the same way as advice to the Cabinet is? Has he interested himself at all in that side of this negotiating process?
Yes, I'm sure we'd all be interested in that if it was available. But the issue on the table is the government in contempt? And it is. And there's reason to believe it is in contempt, because a lot of the legal arguments are simply being taken out. Yes, I will.
I'm very grateful to my honourable friend for giving way. He referred to the suggestion of the Father of the House earlier. Does he recall that the last time a humble address was passed by the House, which instructed the government to hand to the Committee on Exiting the European Union the exit analyses, I made it clear to the government on behalf of the committee at the time that the committee would take the decision about what was released. And in the end, having read all of the pages, from memory, I think we released 36 or 37 of them, but 3 of them we held back because we accepted the argument that the government made at the time that those might not be in the national interest, given that the negotiations were taking place. So there is an example there of a way in which the committee of the House has been able to exercise that judgment on behalf of all members.
Well, I think that intervention is very helpful, and it builds on the proposal of the Father of the House. There is a time constraint here, because obviously the idea of the amendment is to kick this into the long grass so that we don't have full legal clarity to make an informed decision when we vote next Thursday. It is critical that all that legal advice is available to members before then. If there is a facility to enable the redaction of irrelevant and possibly dangerous facts and figures and information in relation to our national interest, our national security, our negotiating position, etc., etc. If that was possible, obviously that would be much better. But the main thing is, are we going to have the full legal advice, or are we going to say, oh, well, what can you do? They've played the national interest card. As my honourable friend has said, there should be, I hope there would be a way through this maze so that we can have the full advice before us before we take that crucial vote. Thank you, Mr. Speaker.
Mr. Kenneth Clark. Well, Mr. Speaker, I follow up entirely on what has just been said by the honourable member for Swansea, he obviously and his colleague have some sympathy with what I said. It seems to me the House is facing an extremely difficult dilemma, which was exactly the one being faced by the Attorney General yesterday. There are 2 very important constitutional principles involved here, which are important to people on all sides in this House, and unfortunately the present situation puts them in direct conflict with each other. The first is the sovereignty of Parliament and the ability of Parliament to instruct the government to do things which the government doesn't want to do. I won't repeat, because I entirely agree with everything my honourable friend, the member for North Somerset, said, that the humble address is an extremely important weapon of this House. It is the duty of Parliament sometimes to instruct the government to do things. Whenever the government loses a vote, we know the government thinks Parliament is wrong. I mean, it disagrees, but it should comply. And I do think Parliament in recent years has greatly weakened its powers vis-à-vis the executive, and we should all think ahead to future parliaments and simply not weaken it any further. The government didn't vote against the motion when it was for the House because the government knew it was going to be defeated. We all know why they asked Conservative members not to vote at all. But I disapprove of that as well. A humble address is an instruction. Actually, I disapprove of refusing to vote on opposition motions and other motions. It may well be constitutionally they're not legally binding, But we've never previously had any government which just said, well, the House of Commons can express opinions if it wants, but as they're not legally binding, we won't bother to attend and not many of us will listen to it. That is a very unpleasant step. And going back, ahead of us are votes on the meaningful vote on the withdrawal agreement, the bill which is necessary to implement that. Particularly on the meaningful vote, I hope the government abandons the idea that the only vote of any legally binding significance is the one on the government's proposal, yes or no. And if the House wants to pass amendments or motions or express a different opinion, well, that's very interesting, a matter of opinion, but the government's going to ignore any amendments. That was virtually what was being urged on the Procedure Committee a few weeks ago, and I hope we'll, when we get on to sorting out the procedure for, well, next week's vote and on amendments and the motion, and on the bill that ultimately follows, we go back to the standard procedure that amendments can be put to government motions before the motion's put. When amendments are carried, then the only vote remaining of the House is whether it approves of the motion as amended. And with great respect, I don't think we should take any notice of all this stuff about, well, government's duty is to listen to what the House says and then decide, in the government's opinion, whether the public interest justifies complying with it. So I'm entirely on the side of the critics. On the other hand, just as my honourable friend from North Somerset said, the Conservative Party would deeply regret when one day it gets an opposition that it's challenged the authority of Parliament. I think the Labour Party might well come to regret when they get into government that their attempts to override the convention that governments are entitled to confidentiality when they get legal advice from the attorney. And I think it's quite ridiculous to throw out either of these principles, because there are occasions when they're both extremely important. I'm not a lawyer in the same rank as my right honourable friend, the Attorney General, though I practiced for many years. I once declined an offer of an appointment as a law officer because I preferred to stay in the departmental job I was then in, but as I'm now totally out of date, I accept that. But I'm very familiar with the circumstances when a lawyer gives advice to his clients. And the legal advice, you give honest opinions of the legal advice. But the advice, actually, of course you're talking about the circumstances of the case, particularly law officers' advice, which I've seen many times when I've been given it as a minister. It's all muddled up. It's a question of policy and the law, arguments about tactics, comments on what the other side might do, all this kind of thing, and advice is given to a client in a way which should be, absolutely 100% should be, an accurate expression of the lawyer's opinion of the law, but it will be coupled with lots of other things, because the lawyer doesn't just sit there ignoring the merits or what the client thinks he wants to achieve or anything else. Well, I'll give way to my honourable friend.
I think he's making a very powerful argument. In fact, what he's saying is that this House shouldn't have to choose between those principles, and what we should have expected was more leadership from both frontbenchers in order to be able to reach a proper, thoughtful solution on how to strike the right balance, just as we have, for example, on security matters already. This is a unique position we find ourselves in, but it was not beyond the wit of the political leaders in our country, I think, to reach a solution and avoid this point.
Well, my honourable friend, my right honourable friend, summarises my argument in a very neat way. Exactly the case. And I actually think, you know, I'm going to do the father of the house, you know, what it used to be like and all that sort of thing. But this is a situation where I would have expected, it usually happened in my time, that the usual channels would sort this out. Oh dear. And perhaps the usual channels were more reliable in the past than they are now. But we get together and agree that, you know, the House has passed a resolution, but there are these problems, and you satisfy the opposition their political desires can be satisfied. They can get all the documents with the embarrassing political opinions of the attorney, but I don't think they'll find much because the attorney is pretty candid. He's a very sound Brexiteer. I mean, he and I do not agree on Europe in the slightest, but you excise things like security we've talked about. It's more, I don't know what's being excluded or being held back, but it's more likely to be comments on the negotiating position of the Commission, the strengths and weaknesses of the government's case and where there are risks. A great deal of a lawyer's advice is, this is my opinion, but the risks involved are this, and some of these comments about other governments and the Commission and so on could well be not in the public interest to disclose. Now, there are reasonable people in this House on both sides, are on the Procedure Committee, and I'd have thought that we should carefully consider where we're going. And I will conclude a bit, I won't take too long, because it's just my one suggestion that I'm pursuing, and I've made it twice now, so I won't labour it too long. But it seems to be likely that this motion we're debating now is going to be carried. There must be a very considerable risk of that. I don't know whether the Chief Whip thinks he's got a majority or not for resisting this motion. Even then, I would hope that we will consider how to do this in a responsible way that doesn't prejudice the national interests or the interests of British governments. Even then, I would hope, I'm not sure the Privilege Committee is the best place to do it, one has to look, as was done in the case of the Brexit Select Committee, as we've been reminded. Have a look at the documents. Somebody nominated as responsible by the opposition, and just give the attorney the opportunity of explaining why he was so obviously yesterday wrestling with a problem of conscience that it simply is not in the national interest to put all this in the newspapers. The previous problem was solved by redactions. I still urge there should be redactions, and nobody in the opposition is going to allow the government just to hold back things which are politically embarrassing, somewhat at odds with what the government is now saying, or advocating a tactic that the government in the end chose not to. All that, because we lost the humble address, I fear on this side we've got to be braced for that if these documents do come out. But there is a public interest in not undermining the confidentiality of the legal advice. So I repeat my suggestion. No one knows where we're going in politics, who will be in government, who will be in opposition for very long. What matters is that this Parliament is not weakened any further, and what matters is the ability of governments of whatever party to rule in the national interest is not undermined. So I repeat my suggestion, and I think if the opposition are victorious, I think they should, in the public interest, just consider how far they wish to press this. I'm sure the House as a whole will accept if they held back in some ways and we got the confidentiality of the law officers left intact.
Order. Just before I call the next member wishing to speak, can I very gently point out to the House that although many members still wish to speak, we have afterwards the business of the House motion to consider and a protected 8 hours for the debate itself. I make this point simply so that members can factor that into the equation and no doubt to take account of the mood of the House. That is the only consideration which I am inviting colleagues to contemplate. From my point of view, there are few joys outside family greater in life than listening to honourable and right honourable members on both sides of the House and with all points of view. I should get out more, somebody says, for a sedentary position. I am the servant of the House, so I'm not complaining. It's a joy, but people might want to bear in mind that their own enthusiasm to speak is not always matched by a comparable enthusiasm of everyone else to hear them. Mr. Chris Bryant, and it's not personally directed. It is not personal. Mr. Chris Bryant.
Your wisdom, Mr. Speaker, in always making that point just before you call me is shared by the whole House, I'm absolutely sure. So we're all united now and everybody can just agree with what I'm about to say. No, can I first of all just say that whilst I sympathise with the arguments that have been made by the father of the House, and for that matter the points that were made by the Honourable Member for Somerset North East, I disagree with the conclusion to which they come. And I'm actually delighted that the motion does not mention the Attorney-General by name, and because I don't think this is a matter of the Attorney-General being a dishonourable man at all. I am very, very fond of the Attorney-General. I think he is a wonderful man. I think he is entirely honourable, and I think yesterday he did his level best in the chamber to provide what he thought he could within the terms, within the strictures that have been given to him by the government. But I would just say that we are today facing a very extraordinary moment. I cannot in the history of Parliament find a moment when the government has referred itself to the Committee on Privileges. It is an extraordinary moment. Its best argument that it has today in response to the motion by my right honourable friend, the member for Holborn St Pancras, is instead of deciding already that on the House's behalf that the government is in contempt, we will refer it to the Committee on Privileges, which always in the past has been a prima facie deciding that there is a case to answer. So the government itself accepts, at the very least, that there is a case to answer, that the government has been in contempt. I cannot think of another moment in our history when that is true. And the attorney himself, in fact, yesterday, as several members have already said, in a sense confessed his own guilt to the charge of contempt. He said, of the debate that we had previously, we should have voted against the motion. Of course we should have done. It would have been good, actually, if the government had made all the arguments they're making today and made yesterday afternoon back in that debate back then. Because some of us might have listened to the argument about national security then. It might have been an appropriate argument then, but it wasn't an appropriate argument yesterday, or for that matter, today. The Minister, the Attorney-General yesterday repeated time and time again that he knew he was not fulfilling the will of the House. That is what we're asked to decide today, whether the government is fulfilling the will of the House. He himself said yesterday that he was not fulfilling the will of the House. And in an extraordinary moment he said, the House has at its disposal the means by which to enforce its will. That is what we're doing now. To all intents and purposes, the Attorney-General yesterday asked us to do what we are doing this afternoon. And I think he fully accepts that the House has to be able to have its way in the end. I would also say to the Honourable Member for Beaconsfield and the Honourable Member for North East Somerset, the other thing that is extraordinary about the motion that is before us, the opposition motion shared by the other opposition parties, is that there is no sanction involved in it. In fact, the only thing that it requires to happen is that the will of the House is abided by. That is the only thing. Now, it may be that we have to return to this if the government chooses to ignore it, but my suspicion, my hope is that if this motion, the opposition motion is carried today, the government will say, all right, fair dues, that's twice we've been told now, we do actually have to abide by the decision of the House. Of course, I give way to the Honourable Gentleman.
Very grateful to the Honourable Gentleman for giving way. I wondered if he could help the House by explaining what the next step would be if the government did not then publish the information, and what procedural effect could be had, or what motion could be brought forward following up on the motion before the House today.
Well, I don't want to go back to 1340 like the Honourable Gentleman, and I'm not going to, but I think I prefer to cross my bridges one at a time. I am hopeful, for all the reasons, the good reasons that the Honourable Gentleman himself adduced earlier, that I'm hopeful that the government will, if the House for the second time decides to abide by seeking the government to enforce, insists on its will for a second time, that the government will then comply. I think, to be honest, if that were not to be the case, then I hope that other honourable members who today are dubious about this procedure would want to stand in favour of more robust measures. The anxiety is, of course, there is a time matter here. We can't let this roll until after next Tuesday, because then there's the government would have completely defied the will of the House beyond the time necessary. Yes, I will, but I'm conscious of the Speaker's...
Yes. The Right Honourable Member, a few moments ago, referred to the will of the House having to be implemented. Does the Right Honourable Member think there should be any limitation at all to the House's ability to impose its will? For example, if the will of the House ever came into conflict with an individual's personal or civil liberties?
Well, I think in the debate that would transpire, I don't think honourable members would vote for such a motion. So it is a hypothetical that he's putting to me, and we've been dealing with lots of hypotheticals. I've tried to search through history to find a moment when the government has refused to abide by the will of the House when there's been a humble address, and I can't find one. I simply cannot find one. So I think we should deal with the actuality rather than the hypothetical. And I simply say to members opposite, it is all very well when you are on the government benches to say, yes, the government should have its way, but actually that doesn't normally serve the long-term interests of the nation. And in our present system, we have the government has phenomenal power. I want to deal with the substantive...
The Right Honourable Gentleman will be aware that often our committees ask for papers, and on those occasions it's sometimes responded to by saying that the documents are legally, professionally privileged. And in those circumstances, the House tends to use a bit of discretion, a bit of common sense, and often will reach an agreement about exactly what is to be disclosed. Isn't that what's needed here?
Well, it would have been interesting if that had been the argument that the government had brought forward, but it wasn't the government's argument. The government made no argument. It agreed with the motion. It allowed it to go through. And if it had said in the meantime, for instance, yesterday afternoon, we will provide the document that you want, we're going to give it to the chair of the DEXU committee. The DEXU committee, which has a majority of Conservative members on it, can decide what should be in the public domain and what shall not be in the public domain. I think the House would have been content with that. That would have been a perfectly logical process to adopt, but that's not what they've done. Now, maybe that's what they'll do later on today, if they lose the motion. I don't know. Can I just go to the very important substantive point, though? The point is, can the House require the law officers, in particular, to provide their legal advice to Parliament? Of course, I think it's important that select committees are able to require documents of all sorts of people outside Parliament, and it's difficult to enforce that if we're not even able to enforce it on government ministers either. But now the Attorney-General referred yesterday several times, he referred to what he called were previous editions of Erskine May, to say that the motion for return, he said, was traditionally always confined to public and official documents. That was his argument for saying that the Erskine May shouldn't really, even though it today does in its present 24th edition, allow that law officers that anything that's sought by the House should be provided. He was trying to argue that previous editions, suggesting like the 22nd edition or the 23rd edition, had changed the rule and that we should return to a previous version. I think what he's referring to is the 10th edition of Erskine May, which the Honourable Member for Somerset North East, I'm sure, will know, came out in 1893. In which the traditional version of this doctrine, which is I think what the Attorney-General is referring to, is laid out. The opinions of the law officers of the Crown, given for the guidance of ministers in any question of diplomacy and state policy, being included in the class of confidential documents, have generally been withheld from Parliament. I think that's what the Attorney-General still believes should be the case, though it's been superseded. It goes on, unfortunately, for the Attorney-General to say, in 1858, however, this rule was, under peculiar and exceptional circumstances, departed from, and the opinion of the law officers of the Crown on the case of the Cagliari was laid before Parliament. I'm not going to go into the instance. I know the honourable members are saddened by that. But the point is that when the House has required that the law officers provide it, the law officers always have provided it. So I don't think that the Attorney-General's argument stands.
Grateful to the honourable gentleman. It also appears in the 17th edition that's from 1964, to which I'll refer if Mr Speaker calls me in due course. The case to which he refers in the middle of the 19th century was where the Minister voluntarily gave up that advice. It was not demanded of the House in these circumstances.
It was required. by the House. In fact, by both Houses, both the House of Lords and the House of Commons. And indeed, the point was in the 1893 version, which survived for a while, was that this was under peculiar and exceptional circumstances, but they were remarkably peculiar and exceptional in the same way as the instance is here, because it dealt with international treaties and the relationship between other countries in Europe. The point is, in the end, the House must surely be able to require documents. There must be a point at which, just as the Speaker is the servant of the House, so in the end the government has to bow the knee to Parliament. And it's not good enough for the government, I think, just to say, well, you're all wrong, you're benighted, you don't understand the full implications. We, the government, are the only people who've really seen all the truth and understand the security implications and all the rest of it. If they want to find some other arbitration method through the process of the House, such as one of the select committees, fine, go through that. But that's not what they've done. And in the end, we come to this simple point, which I don't think a single one of my constituents would understand, which is that the government looks as if it's trying to keep something secret. That the law officers want to say one thing in private in Cabinet and another thing in Parliament. That is not to accuse anybody of hypocrisy. It's just very simply to say that my constituents simply wouldn't understand why the government would want to keep this secret. And to government members I say, one day you'll be on these benches, and if you vote against this being a contempt, and against, therefore, requiring the government to produce these documents, that power will be gone forever.
In inviting an illustrious lawyer next to address the House, it is perhaps more in hope than in expectation that I reiterate the plea for brevity. Mr. Bob Neal.
Well, I'm very grateful, Mr. Speaker, and in an endeavour to meet that injunction, can I say, as lawyers would, that I adopt most of the arguments made by my right honourable and learned friend, the member for Beaconsfield. Particularly, he's mastered the analysis of some of the matters, and I don't intend to repeat them. What I do think important, however, is that we do recognise that there is potentially a conflict between two important concepts here. That is the revived use of the humble address, which may indeed be of value to the House going forward, but also the imperative of protecting both the concept of lawyer-client privilege in general, and in particular as that relates to advice given in government. And having been a much less distinguished member of government in the past, I confirm entirely what my right honourable and learned friend, the member for Rushcliffe, said about the way in which legal advice is received by ministers. It's as if it's rather conceived that there is a little bit like in private practice, where you're asked to produce one big rolled-up opinion as a nice document that you charge for appropriately. That isn't the way it actually happens in practice here. So I do think we need to draw that distinction. And there is then the second point about the particular nature of the Law Officers' Convention and the fact that, of course, that goes, in a sense, beyond the normal role of lawyer-client privilege. And in particular, the point I think is the Honourable Member for the Rhondda rightly conceded that it's wrong to attack the Attorney General in this, because he is not the client in this context. He is the government's lawyer, and having known the Right Honourable and learned gentleman, the Attorney General, professionally and personally for the better part of 30 years, I absolutely have faith in his integrity and that he did everything he could in this House to meet the injunctions that were placed upon him. And I have absolute confidence that he spoke frankly and would not, as was I think rather unworthily suggested by the Honourable Member for Shortland and Wallington, who is not in his place, to cherry-pick. That's not the way my right honourable and learned friend has ever approached his responsibilities as a lawyer or as a politician. In a sense, that's putting the wrong person in the dock. I will support the government's amendment in this, because it does seem to me that these two conflicts between the use of the humble address and the protection of parliamentary privilege require something more than the summary disposal that will come at the end simply of this debate. It is a matter that warrants serious consideration how you deal with the interaction of those two matters. If the humble address is to be updated, maybe it's not just a matter for the Privileges Committee, but for the Procedure Committee to look at as well. And I offer that as a constructive suggestion. But in terms of what is the proportionate way forward, it does seem to me that the Privileges Committee is best placed to consider this on an evidence-based and dispassionate and considered basis, and therefore I support that. And it may be that the option floated by the leader, the father of the House, my right honourable and learned friend, is one of the things that they might look at in that context. But as for today, I would urge that we accept the government's motion and do not imperil what is a fundamental legal and constitutional privilege.
Yeah. Mr. Peterbone.
Oh, thank you very much, Mr. Speaker. Much of the debate today has been about what the debate should have been back in November. So I'm going to dismiss those because actually in that debate, had a vote taken place, I would have voted with the government. But they didn't put it to the vote and they accepted the motion, and that's a matter of fact. So it's clear, but not providing the information is a contempt. But the father of the House and the member for North East Somerset argued the problem that it breached the other important aspect of confidential legal advice for the government, which I also accept. But it seems to me the only way we will get to getting something like the father of the House has suggested is if we vote for the contempt motion, so that the government can then come back overnight, if necessary, to suggest that option. I do not see how we get to that if we vote for the amendment, because it will go off to the Privileged Committee. So I was undecided before I came in to the Chamber, but because of the arguments of the member for North East Somerset and the father of the House, and for the matter the member for Rhondda, it seems to me, because the motion laid before the House, signed by the spokesman for 6 different parties in this House, is not actually critical about any particular minister, and all it says is what the original motion said, or in fact perhaps even more precise than the original motion, about publishing the legal advice. So unless something very dramatically changes between now and the end of the debate, and I do have to leave the Chamber, sir, as the Chief Whip would like to have a word with me sometimes. I do think that if the House votes for the contempt, a compromise will happen and we will get, hopefully, properly redacted information before we vote next Tuesday.
Sir Bernard Jenkin.
I'm most grateful, Mr. Speaker, and particularly that you should call me after I sat through this debate and listened before I decided to speak. That may be unusual. But the reason I rise is because the Public Affairs and the Public Administration and Constitutional Affairs Committee is in fact in the process of concluding our inquiry concerning the status of resolutions of this House, and we have been looking at the questions of what we call motions of return and how they should be dealt with and what their legal status is. How the government responds to a humble address at the moment is merely a matter of precedent and convention. It is not a matter of law, not a matter of statute law or of common law. So this is not a device which should be overused or used irresponsibly, though I'm not casting any aspersions on anybody's motives, but I just make that observation. Because this House operates on the basis that it is not the government. The government exists as a separate legal entity which functions when this House is not sitting, when Parliament is prorogued, and even when Parliament is dissolved. Parliament holds ministers to account, and we scrutinise the work of government. We make the laws which bind the government, and this House controls the supply of money to the government and to the Crown. But we do not run the government, and we have parliamentary government, but not government by Parliament. And the point about labouring this little constitutional essay is, if we forget that, then there is confusion. and we risk creating more confusion about how the distinct roles and responsibilities of Parliament and Government have to be divided if we use our powers and procedures irresponsibly or unpredictably or in the wrong circumstances, or, dare I say, as a bit of oppositionism. So where does that leave this humble address? A device that until very recently wasn't used until the 1850s. Until we found ourselves in this very abnormal political atmosphere. And I'll come back to that point in a moment. This device, known as a motion of return, if this was to be used indiscriminately and frequently, it would be impossible to conduct the business of government. If the opposition was to use the vulnerability of the government to demand the advice to ministers as well as legal advice, the minutes of internal meetings or previous drafts of policy or speeches or indeed matters of national security. And of course that doesn't happen because we rely on the self-restraint of Parliament. The credibility of the unwritten powers of this House depends on their responsible exercise. As they cease to have credibility, they will not be respected. And incidentally, the committee just returned from a visit to the US Congress, where they have a written constitution which you think might provide all kinds of solutions to this, and it doesn't. They're suffering from exactly the same problems, exactly the same kind of breakdown in the understanding of the norms and conventions that surround their written constitution. So even in the United States, it's not unknown for the executive to ignore new laws passed by Congress. Now, I referred earlier to this normal atmosphere that we usually enjoy in politics, and how, until very recently, these motions for return seem to have fallen into what our learned clerks call desuetude, i.e. they had ceased to be recognised as functioning bits of the Constitution. So why is it being revived now? Well, first of all, we have a minority parliament. In particular, we have a minority parliament where the confidence and supply agreement with the Democratic Unionist Party appears to have broken down. And secondly, as in the US, politics has become extremely polarised, and particularly between the two factions of Remain and Leave, where the referendum demonstrated that the balance of opinion is different in the country than it might be in this House, and that presents particular challenges. And incidentally, just as in the US, the third point, there is a breakdown of trust in politicians generally, and trust, restraint and respect between the political parties and between the factions. We've noticed, haven't we, how deeply embittered some of the political arguments are around, particularly around the referendum and European Union question. And norms of procedure, just in the United States, and of convention have become overshadowed by partisan dispute and political opportunism. And I would just invite the House to look at the United States and the endless confected rows about matters supposedly of fundamental constitutional importance, which we can see from this distance are really just partisan politics. Now, there is a strong case for reviewing and codifying in some way many of the ancient devices and procedures and powers of this House, but that does not resolve what we should do today. The Right Honourable Learned Gentleman for Holborn and St Pancras underlined the real weakness of the justice in his case, and its weakness as a matter of procedure that is in the public interest, when he warned the government that the government faced being, and I quote, found in contempt of the House, unquote. That supposes we are a High Court of Parliament, which we are, and we are operating as some kind of judicial authority on this matter. But of course, this chamber is not behaving like anything we would recognise as a court. I'm afraid this vote is likely to divide on party lines. There's very little objective about this binding of contempt which he invites the House to do in this debate. So I think the government has made a sensible compromise. The Honourable Gentleman for Rhondda, Right Honourable Gentleman for Rhondda, said the government seemed to admit that they were in contempt. This amendment is an admission there may be a contempt by referring the matter to the Privileges Committee, where there might be a slightly less partisan and heated and more objective there might be a more objective atmosphere, and where some of the ideas and procedures for sorting this out as quickly as possible could be reached. And I would just invite my right honourable friend to consider whether she would accept a little addition to her amendment, that the committee should be required to report by 10 p.m. on Monday. So there is no suggestion that the committee is being used as a device to knock this into the park, the long grass. I'm going to give her my unqualified support for her amendment anyway, but I do suggest that she could accept that, or at least invite the committee to report early next week in time for the debate. Not that I think many people are going to change their minds as a result of what the government may or may not publish. I don't think that's... I mean, I think that this issue has got caught up in this great dispute about our future relationship with Europe. It's the elephant in the room around this debate, and this is not necessarily the best circumstance under which the absolutist device of a humble address should have been exercised in the first place.
John Barron.
Speaker, I'm neither a lawyer nor a constitutional historian, but I concur with the Father of the House and indeed the member for North East Somerset in suggesting that I think it's regrettable that we have got to this position, and one wouldn't certainly from our benches, start from this position if we had to choose. But we have to, as honourable members, make a decision about the facts before us. And the point I would put to the opposition is that they have failed to answer one very obvious question. And that is, their motion is a take it or leave it, all or nothing approach, which doesn't recognise the sensitivities of the situation at hand that has been built up by convention over decades, if not centuries, in trying to balance the will of Parliament with the national interest. Now, I, and many of us in this place, have no problem with the concept that the will of the House of Commons should be recognised by the government. But there is a delicate balance here when it comes to issues of national interest. I don't think there's anybody in this place that would question the national interest when it comes to, for example, the role of our special services, or the role of our intelligence services, or indeed cabinet minutes, freshly laid. I think that's generally accepted. But there is a grey area here that we have to approach very carefully, and the opposition's all or nothing approach, Mr. Speaker, risks establishing a principle that they may come to regret one day. It is very important indeed that there is honesty and honour in this place, but that has to also recognise the fact that there needs to be a filter when it comes to claims about national interest by governments. And the opposition motion lacks that filter. What you would be doing, not you, Mr. Speaker, I do apologise, what the opposition would be doing is putting everything out on the table, and there may be issues in that disclosure which would be sensitive when it comes to the national interest. It is a reckless idea. It is a reckless idea that risks riding roughshod over decades of convention when it comes to trying to establish that balance. Now, I make no bones about it. I do not like where we are as a government with regards to this issue. But we have to judge the situation as it is now. And as it is now, I think the filter, Mr. Speaker, that could achieve the delicate balance that is needed in this situation is the filter with regards to the Committee on Privileges, because although not a perfect answer to this situation, it would serve to act as a means of filtering that information which perhaps is against the national interest. So I, Mr. Speaker, will be supporting the amendment this afternoon, one hopes. But I do urge the opposition to think this through very carefully, because I think the balance of opinion, the government may lose this, but I would suggest the opposition acts with restraint in the follow-up, because I think there was a real danger here that they could one day regret what they've done, and they should be careful what they wish for.
Mr. David Linden.
Thank you very much indeed, Mr. Speaker. I'm very grateful for the opportunity to contribute to the debate, and I believe that so far I think I'm the newest member to contribute to the debate, so this is clearly the first time that I've witnessed a privileged motion coming before the House. And I just want to reflect on how we've come to this position, and I had to nip out for 5 or 6 minutes to attend Delegated Legislation Committee this afternoon. The government at that Delegated Legislation Committee were talking about the importance of the humble address before the Delegated Legislation Committee and how the House must adhere to this. And I'd been reflecting on the fact that before that I had been down here, and we find ourselves in the very sorry circumstances of us debating a privileged motion before the House, which is somewhat unprecedented for the vast majority of members in this House. But I just wanted to offer a reflection since I entered the House in 2017, because time after time we have seen this government ride roughshod over this Parliament. This is a Parliament that's meant to be taking back control, but it's a Parliament that's being denied a money resolution. It's a Parliament that's not adhering to opposition day votes. It's a Parliament that is not adhering to a binding motion of the House calling for the release of this legal advice. It might be uncomfortable for the government to release that legal advice, but the reality is the House has voted for that. And for members who claim regularly that Brexit is an opportunity for us to take back control, well, I'm afraid, Mr. Speaker, the members of this House and the benches opposite cannot have their cake and eat it. If they are serious about the House taking back control, if they are serious about adhering to the will of the House that was outlined in November when the original motion was passed, then they'll vote for the motion in the name of the honourable gentleman tonight.
Thank you. Dr. Andrew Mirison.
Mr. Speaker, if I may say so, a number of interesting things have come out during the course of this debate around our general procedures and our way of handling matters of the sort we've been discussing. Has to do with procedures, privileges, has to do with the nature of the humble address and whether indeed it's an appropriate vehicle for advancing the essentially political aims of the party opposite. On one thing I think we can agree, that is that we need to find a sensible way through that. And it seems to me that the amendment that the government has put forward, though not perfect, is a sensible way through this particular conundrum. The government clearly is not in principle averse to being as transparent as possible, but it does have to safeguard the national interest. My right honourable friend, the member for Rushcliffe, made a sensible suggestion, as one would expect, in relation to the use of Privy Councillors, perhaps, to examine this matter. But we do, of course, have the Privilege Committee, which is up and running already, and although it's imperfect, as a number of right honourable members have said, for the purposes of examining this, it is at least there, and is something I think we could support in relation to determining whether the very serious charges around contempt are reasonable or not. And I think we do have to understand that some quite serious allegations have been made here. Lawyers and, of course, legislators understand full well what contempt is. The general public probably think it means something rather different, and they can be forgiven for that. Contempt is a very harsh term, and if it's associated with individuals, then, and I'm not suggesting, of course, the Attorney General has necessarily been associated with this, but ministers have been, and it sticks, that's a very serious matter, even if we haven't decided yet what the penalty might be. Of course, when this language was being got up hundreds of years ago, the penalties may have been very severe indeed. Mercifully today, that is not the case. But we have yet to determine what happens if individuals are found to be in contempt. That is left uncertain. But one thing I think we can agree on is it's a very serious allegation to make, and the consequences potentially are significant. So we have to get this right. And simply to use an arcane measure like the humble address to make this determination untrammelled seems to me to be unfair.
So if we accept that it is a rather archaic vehicle that's more traditionally used not for legislation or for things that might lead to legislation, but for things like providing gifts to Commonwealth countries, as suggested in Erskine May, which I cited earlier in my intervention on the Honourable Member for North East Somerset, then we have to also accept the possibility of using a measure that is not ideal for determining that, and that means the Privilege Committee, in my view. Of course, I'll give way.
The honourable gentleman for giving way. Will he not agree with me that what's really upset both sides of the House is the fact that the government, on a number of occasions now, have ignored the will of the House, and I think that's antagonised a lot of members. Would you not agree with
the honourable gentleman is right. Of course, the difficulty we've got is that a court of law has available to it a judge who can make a determination on what might be disclosed and what might not be. Indeed, we had the Freedom of Information Act passed fairly recently in this place, which put very significant constraints on what might be disclosed and gave powers to the Information Commissioner to use his discretion to permit or otherwise information entering the public domain. But we don't have that here. And the government, of course, is very mindful not only of this setting precedent, but of the very real possibility that, who knows, in the advice given by the Attorney-General in this specific case, there may be issues that might be embarrassing for this country internationally, or indeed may have some form of security implication. And I think it's irresponsible for this House not to recognise that dilemma that the government now faces, and a government that is trying to reconcile its duty to be as candid as it possibly can with its duty also to safeguard the public interest, and specifically the interests of individuals who might be adversely affected in a very direct way by disclosure of the sort that we are discussing. In terms of contempt, I think it's just appropriate to dwell for one moment on the nature of the advice that the Attorney-General gave the House yesterday. And nobody, surely, in this place could fail to have been impressed by the candour with which the Attorney-General conducted himself. It seems to me to be wholly inappropriate to associate the word contempt with anything that my right honourable friend talked about yesterday. I would say, just in conclusion, Mr. Speaker, that I have grave reservations as a former minister in the MOD and the Northern Ireland Office around the potential that this business that we're discussing today has for the disclosure of information that may be sensitive. That worries me, knowing what I do about the nature of some of the material that the government would like to keep unto itself. It has nothing to do with previous precedent that has been cited today in relation to the Iraq War in 2003, which came 2 years after the event, and in any event dealt with whether the government had behaved lawfully or not. That is not a question that faces this House today. Clearly, the government is behaving lawfully. So the two simply cannot be compared or contrasted in any way at all. It seems to me that the proposition the government has put forward to this House by way of its amendment is a sensible and pragmatic way forward that reconciles the desire the House has for openness and transparency with the government's legitimate desire to ensure that it puts nothing in the public domain that might harm individuals or set a dangerous precedent.
Mr. Robert Courts.
Thank you very much, Mr. Speaker. It's an honour to rise to speak in this important debate today and to follow the honourable member for South West Wiltshire, who's made some excellent points, with most of which, if not all of which, I agree. It is worth restating the fundamental issue, Mr. Speaker, that we are dealing with today, which is the clash between Parliament as a sovereign institution and the highest court in the land, and the right of the government, any government, to have access to independent, unvarnished, honest legal advice. And I would suggest that this is a moment where we all members from every side of the House, ought to engage in a period of cool, calm reflection. And I would further suggest that the government's amendment is the correct way to do this. Because, yes.
I thank the honourable member for giving way. Would he also agree with me that there's another convention as well, is that traditionally the law officer's advice can only actually be released with their consent, and actually for the thing to be revealed it's happened, now that's self-evident via a statement, but actually there's that other parts of the conventions as well.
I'm very grateful to the Honourable Member for Torbay, who, as always, makes an excellent contribution. Normally, it is the case that a client is the person who has the ability to waive legal advice if they wish. In the case of government law officers, there clearly is another layer to that, and their position is, of course, of enormous importance as well. I suggest that the government's amendment to the motion that's before us today is the correct, cool, calm way to look at this matter. Because we are, Mr. Speaker, in uncharted territory. And I would suggest that the very fact that we're all discussing constitutional and historical precedents today means that we ought, all of us, to avail ourselves of more time in which to study those in detail, so that the House, or rather the Procedure Committee, is able to consider the real constitutional and historical ramifications of any decision that we take today. There's a number of questions to which I will be quite honest that I don't know the answer to. Things like, does a humble address trump privilege? It would be helpful if somebody were to look into that and consider it. I don't think there's a straightforward answer to that, because I don't think it's ever been tested. I may be wrong. My point is simply that a period of cool, calm reflection to look into such points would be of benefit to everybody in the House. Further, where does the line fall in terms of disclosure? Is there to be a question of redacting elements of advice? If there is to be a line in terms of disclosure and redaction, where does it fall? Many members of the House would be quite clear that the point would fall at which we're dealing with national security. Relatively straightforward, perhaps. But what about the national interest? The national interest is something that is not so easy to define, and is something that we ought to consider carefully before rushing into what are extremely serious matters, not just of party politics, although of course there is a big element of party politics in what we're discussing today, but in terms of constitutional and legal theory and practice, which will have profound consequences, potentially, for any government. And those on the opposite side ought to be aware that at some stage, I hope not for a very long time, but at some stage it may be them sitting in this place, and they should consider the position they would wish to take.
Which my honourable friend for giving way. Is he interested, as I am, with the position of the European Commission in this? Because I think a number of right honourable colleagues would be interested in the legal service of the European Commission's advice to the European Commission, and I suspect they would take a very dim view of any request that may prejudice the position being taken by the European Commission's negotiators at the moment.
Honourable Member makes an excellent point, which is that in the middle of a negotiation, any discussion that is by necessity high profile and tense, any position that undermines any negotiator by disclosure of advice clearly is something that is to be regretted. The European Commission will, of course, have its legal advice. We perhaps all might like to see what it is. There's a good reason why we can't see it. There's a very good reason why they shouldn't be able to see what ours is. The reason why I suggest the government is approaching this in a better way than the motion that's been put in front of us by the opposition is that that's been touched on by a number of members earlier, that this is an arcane procedure. This is not something that was designed to deal with this situation. I see here from a sedentary position the comment that the whole House is arcane. The whole House is old, and it is historic, and it is flexible. But this procedure has not been used for many years, and it is designed not for a position of such sensitivity as this. It's designed for the production of documents, not for legal advice.
Just wonder what my honourable friend might think about how the Director, say, of Public Prosecutions might think if he were asked to give private legal advice, that would then be made public?
That's exactly right. That's an excellent point made by...
Just to make clear that if and when I was ordered as Director of Public Prosecutions to do something by order, I complied.
Well, I'm grateful to the honourable member for having made that point. He, of course, does have some considerable experience in these matters. But we deal with a wholly different consideration in this case. He deals with a situation where he has been subject to a court order, which brings me on precisely to the point I'm making now. I accept, he will say to me, Parliament is a court, it's the High Court of Parliament, it's the highest court in the land, and I accept the force in that point. But the court that he has been used to appearing in front of, the court that I have been used to appearing in front of at the bar, has a procedure for dealing with such matters that we do not have here. A number of people have already referred to the Freedom of Information Act, which has exemptions for certain purposes. He will also be aware of PII, public interest immunity applications, which take place when you are prosecuting cases where a judge can look confidentially at documents and there can be redactions and so forth. None of that applies here because this procedure is not designed for the purpose for which it is being employed by the opposition. There simply is no mechanism for this procedure to deal with the issues of the gravity with which we're dealing with. To its great credit, the government's proposal does offer a way of looking at that.
Sued Rupert Murdoch for hacking my phone. The court required him, under the Norwich Pharmacal procedures, to provide all the documents. And they legally had to. If they didn't, they were in contempt. That's exactly the parallel here.
But he's right, but he refers to something wholly different. The honourable member makes a good point. He's referring to disclosure, not waiving privilege. They are wholly different. Any member who is... I'm sorry, but the two are so wholly different concepts. I don't wish to be to sound patronising to the honourable member, but the issue that, as any lawyer will realise, including those on the front bench, is that legal privilege is protected. That's totally different from disclosure of relevant documents, where you are expected by court to disclose documents that can assist the other side. And in fact, for prosecution, there's a very good one where you are expected to disclose documents which undermine your case or can be reasonably expected to assist the other sides. That's wholly different, and there are procedures which are laid down in law through practice, through regulation, which deal with those situations. They do not apply here because they don't exist, and they do not apply with regards to legal privilege, which is the crucial difference that I make here. And it's essentially because there is no mechanism to weigh, under the humble address procedure, all of these subtle points that we've been discussing today. I will end my short remarks by just making the point that the Attorney-General has come down to the House, has spent 2.5 hours answering questions, and he's here today, with absolute honesty and candour, strikingly so. The issue, and he's given a number of points which honourable members will be reflecting upon. He was, and I apologise for summarising the points he made, but I think essentially with regards to the backstop, he'll correct me if I'm wrong, there is a risk that it may be indefinite. I think was the point I asked him. He kindly agreed that that was a sound analysis. But his point can be summarised by that's as far as the legal advice can go. Disclosure of legal advice will not provide answers. It will only take the House's consideration so far. After that, it's a political judgment. The political judgment that we have to decide over the course of the next week is one for us. It's one for us on a political basis. It's not one where there will be an answer given on the basis of legal advice, whatever standpoint you take upon Brexit or upon the Prime Minister's Brexit deal. So given the fact that that legal advice will not give an answer, honourable members ought not to consider to continue to pursue the disclosure of legal advice as if it will be some kind of panacea that will provide something that we do not already know. We already have those points. We understand the impact upon what has been negotiated, because we can read it for ourselves in the withdrawal agreement. We understand what the Attorney-General thinks, because he's told us. That is as far as legal advice can take us, because we are not debating over the course of the next week whether what the government proposes to do is legal. We are proposing to debate whether or not it is something we think the government should do as a matter of politics and policy, and those are wholly different. Mr. Deputy Speaker, I'm very grateful, but the committee is the right place to consider this matter as the government has suggested, and I ask the whole House to support the government and not the opposition.
And David T.C. Davis.
Thank you, Mr. Speaker. Mr. Speaker, publishing the legal advice on the Brexit bill would be a dangerous precedent. These are not my words. These are the words of Mike Russell, MSP, who back in March was the Scottish National Party's Brexit minister, talking about the Scottish Brexit Continuity Bill. He refused to publish the legal advice because he said it would set a dangerous precedent. Of course I will.
Can the honourable gentleman advise, was there a motion in the Scottish Parliament to advise him that he had to do that?
I'm sorry, I didn't quite catch that.
Trying to plan how long he's going to speak this afternoon. Can he advise, for the record, was there a motion passed in the Scottish Parliament asking him to do that?
Mr. Speaker, I'm not an expert on the Scottish Parliament. I'm not an expert, but I do know that the SNP minister, yes, the member laughs, the SNP minister was refusing to publish this advice. It's on the front page of the Scotsman back in March. He refused to publish it because he said it was a dangerous precedent. And the fact of the matter is, Mr. Speaker, that governments across the United Kingdom, governments of all political parties, the SNP included, know that they have to have the right to be able to get legal advice without that advice being published. Not just governments, but local authorities, even, dare I say it, the House of Commons authorities are able to get hold of legal advice. And it's very important that that advice remains confidential. Important because if it doesn't, the danger is that at best that advice will become a political football kicked around by members of all parties, using the information to try and buttress the arguments they wish to put forward, or at worst, a stick which could be used to beat our own government by the governments of other nations who may, during complex negotiation processes, have aims that differ very much from our own. So what the government have been doing is not defending the information about Brexit, because we already know what the problem is. I'm an ardent Brexiteer. I already knew that the problem was going to be over the backstop. None of the information that has come out since then, none of the information that was leaked rather unhelpfully over the weekend, has changed anything. We already knew that the problem was the backstop, and we're no doubt going to be spending more than a few minutes debating that over the next couple of days. But if anything, I've been reassured by what I've seen. Reassured that the government have at least been behaving honourably, because we haven't learned a single thing in the leaks that came out over the weekend that we didn't already know about. There has been no smoking gun, no hidden information. So the principle is what the government have been defending. The important principle that the information that they access remains confidential. And not only are the SNP being somewhat inconsistent, but so are members of the Labour Party. They already have a Labour government in Wales. And that Labour government is not known for its approach to openness. And I can certainly say to honourable members opposite that I've submitted numerous freedom of information requests to the Labour government, which haven't been properly dealt with, and I'm pretty certain that they're not going to start publishing the information that they get from their legal officers. May I say to my friends in the Liberal Democrats, it's not simply a Labour government in Cardiff. There's a Liberal Democrat education minister. Wonderful though she is she going to start publishing the information that she gets from her law officers when she decides to close down school sixth forms, as has happened in my own constituency? I'd like to think that she might, but I doubt it very much, and I doubt whether the honourable member will be asking her to do so. Mr. Speaker, what I detect here is a whiff of inconsistency from members opposite, a whiff of inconsistency from those who for years have accepted that governments and public authorities have the right to independent, impartial, confidential legal advice, and who know perfectly well that if that advice is going to be offered up in public, then it will no longer be sought. This is not an attempt to get openness. This is yet another attempt to subvert the will of the people who, in a referendum in 2016, clearly voted to leave the European Union. And that is why I will be supporting the government amendment tonight.
Andrew Bowie.
Speaker. Mr. Speaker, I rise to speak in this debate as something unusual this afternoon, and namely not a lawyer. However, I am a passionate believer. I am a passionate believer that the conventions of how we as a government and how we conduct the business of government should be respected, and that these conventions we abide by are there for a reason. And I believe that we must protect the integrity of the law officers to advise the government. The ramifications of not doing so, the ramifications of publishing legal advice given to a government, could be hugely damaging. I do wonder if, and it will be when the other side are in government, as they surely will be one day, they will be as keen as they ask us to be to publish confidential legal advice. Now, members are unlucky because I was considering withdrawing from this debate, but following the comments earlier from the honourable member from Glenrothes, I didn't feel that I could let that pass without commenting on the rank almost near parody of the position that the SNP find themselves in attaching their names to this amendment. Let me take the House back to October 2012, when the then First Minister Alex Salmond was asked by members of the Scottish Parliament to confirm whether he had sought legal advice over whether Scotland could continue to be a member of the European Union if it was to gain independence in 2014. Now, notwithstanding the fact that it transpired that thousands of pounds of taxpayers' money was spent to cover up the fact that no legal advice was actually sought, in an answer to a question on this very topic to the BBC's Andrew Neil, the former First Minister said, and I quote, "You know that I can't give you the legal advice or reveal the legal advice of law officers." I would be delighted to get... Mr.
I'm very grateful to the honourable gentleman, for whom I do hold in very high regard, but I think he is missing a point here. There is a difference between being questioned by the BBC about legal advice and Parliament having a binding vote, which is why a contempt motion has been brought before the House today.
I fully respect the honourable member, as he knows as well, and I would put back to him that the Scottish Government in their actions have shown themselves to be disrespectful of the Scottish Parliament on binding motions. I'll put, for example, I will just in a second. For example, on primary one testing, or on the named persons legislation, or on fracking when the Scottish Government abstained, or possibly on the Offensive Behaviour at Football Act, all of which they have just they decided were advisory motions that the government didn't have to abide to. Yes, I will give way.
I'm interested that the honourable member has said the Scottish Government decided these were advisory motions. Is it not a fact that under the standing orders of the Scottish Parliament they were advisory motions, exactly like the advisory motions on opposition benches that this government has ignored for the last 4 years? Can he give a single instance when a binding motion of the Scottish Parliament has not been complied with by the Scottish Government or indeed the Scottish Executive prior to 2007? A single example would do.
I'm not here to debate these issues. I'm here to point out the rank hypocrisy of the Scottish National Party in putting their names to a motion that demands that this government publish legal advice when they themselves, on countless occasions, including, as my honourable friend, the member from Monmouth, has pointed out recently, when the Scottish Government's own Brexit minister refused to publish their own legal advice for their continuity bill. So as I ask the members of the Scottish National Party, what has changed? Have they changed their minds on this? And do they believe now that it's in the interest of the country and the interest of all governments at every level, from here at Westminster to Holyrood to Cardiff to Belfast, to publish legal advice in full? If so, that's quite a change from where they were 6 years ago, quite a change from where they were 6 weeks ago, and it would prove some interesting questions to come on the floor of the Scottish Parliament. I would be delighted to give way to my honourable friend.
I'm grateful to my honourable friend for giving way. So it seems to me that both the SNP and indeed the former Director of Public Prosecutions is arguing that if Parliament passes a motion, then even if it might not be in the public interest, the government has to comply with that motion. Then does it follow, therefore, that if Parliament were to pass a motion that MI5 or MI6 were to open its files and make it public, the government should naturally do that?
I wholeheartedly agree with the first part of my honourable friend's question. I have enough respect for the honourable member sitting opposite to hope that the second part of his question would never come to pass. I don't think that even the Labour Party today or the Scottish National Party would think it was in the national interest to ask the government to open files from MI5. I sincerely hope not anyway. But I must actually take issue with one of the comments raised by the Honourable Member for Glenrothes when he described this government as being dictatorial. And on this I will finish. This is from a member of the Scottish National Party whose government has the worst record in publishing FOI requests of any legislator, any administration in the United Kingdom. I think that he should look closer to home when he starts throwing stones like that. And I will conclude now, as I know there are other speakers who wish to get in, and I'm conscious of Mr. Speaker's advice that not all members are as keen to hear my voice as I am. Although I'm sure my honourable friend across, as he seems delighted to hear me speaking this afternoon. Yes, but I just want to put on record my support for the amendment as put forward by my honourable friend, the Leader of the House. I think members of this House have a duty to consider the ramifications of their actions and the consequences of what they might be doing today for short-term political gain. And I think members must consider the full constitutional and the historic context of what they ask in this House. I believe that by standing in this House yesterday and by answering questions from all sides, and also by making himself available to any colleague with further questions, the Attorney-General has proven himself to be more than respectful of this House, and certainly not in contempt.
Mr. Alex Chaw. Speaker, and just a few words. It's been said in the course of this debate more than once that this is the High Court of Parliament. Now, my constituents, or indeed anyone else watching this debate, might assume that that is some historic nicety and arcane expression, but it's far more important than that. Because in the context of these proceedings, it is this court which has the ability to achieve the conviction, punishment and disgrace of one of our number. And therefore, it's critically important that when it does so, it complies with what we might have thought to be natural rules of fairness, but also, in the present context, other important statutory limits. Most obviously, of course, the European Convention on Human Rights. Why does that matter? Well, any court, be it the Magistrates' Court, the Crown Court, the High Court, the Court of Appeal, must ensure that its proceedings are fair. Never was that more important than here too in the High Court of Parliament. Because it is no defence to say, well, we are seeking to condemn the government as a whole. In the court of public opinion, assumptions and judgments will be made about precisely who is being identified. And if there were any doubt about that, it is made clear in the press, which is already circulating in social media, about who it is who stands to be condemned. And in those circumstances, we need to be very careful in this House to ensure that what is taking place is truly fair. Well, if this were criminal proceedings in an ordinary court, the Magistrates' Court or the Crown Court, the first question would be, what precisely is it that is being charged? What is the matter which has been breached? And I would suggest, Mr. Speaker, that there is serious confusion about what was ordered on the last occasion. That's to say, the proceedings on the 13th of November. Because on that occasion, the written document, the motion that came before the House was as follows: that an humble address be presented to Her Majesty, that she will be graciously pleased to give directions that the following papers be laid before Parliament. Any legal advice in full. In the course of those proceedings, perfectly properly no doubt, an attempt was made to seek to amend that motion. Labour's front bench made it clear, as I'm reading now from their document that was submitted to the House yesterday, the motion requires the publication, they say, of the final and full advice. Leaving to one side for a moment precisely what is meant by final and full, leaving aside whether in fact those two adjectives are capable of pulling in different directions, there must remain, I would suggest, Mr. Speaker, some confusion, not yet, some confusion, but I will in due course, forgive me, about precisely what happened. Because there were two honourable members in this House who sought to clarify what it was we were being asked to vote upon. The honourable member for Thirsk and Malton and the honourable member for Banbury, who I see in her place. It was Mr. Speaker who then said this: "Order. I'm extremely grateful to the honourable lady," he said to the honourable member for Banbury. "It might profit her and all members of the House if they listen to the development of the argument in which the Shadow Secretary of State is engaged. Frankly, it is not really very confusing at all. There is a motion, and members can read the motion and form their own view of it. In that remark, it seemed to me, Mr. Speaker, that you were saying, look at the text, it's tolerably plain. But then, when the honourable member for Chelmsford said, I am unclear, are you asking for publication of the final advice, which is what was being proposed orally, or any legal advice? And again, although it's not necessarily for me to give evidence, there was a state of some confusion at the end of the proceedings on the 13th of November about precisely what had been ordered. Now that matters because, just let me just finish this point and then of course I will come to the honourable gentleman. That matters because the wording that appears in this motion is the latter, not the former. In other words, it is what is amended. Now that is very significant. Now I'll just finish this point because if you were applying the European Convention as I've indicated before, first of all, proceedings must be fair, Article 6, but also Article 7 says there is no punishment without law. In other words, it's got to be crystal clear precisely what it is that is alleged to have been contravened. And I want to make the basic point that there was considerable confusion in this House about precisely what had been traduced. Yeah, or what had been ordered. Go ahead, please.
Thank you, Mr. Speaker. I do thank the honourable gentleman for giving way, and I remember being here when this debate happened, and there was initially some confusion. But what I would say to the honourable gentleman, and I would ask is, if such confusion reigned, why did the government not oppose the motion at that time? It is all well and good to say now that it was unclear, but that was not the argument that was progressed at the time.
I'm very grateful to the honourable gentleman, but respectfully, that's not right, because what the honourable member for Chelmsford said is this: I am deeply unclear. Are you, and Mr. Speaker quite rightly intervened saying, well, who are you referring to? But she said, are you asking for publication of the final advice or of any advice in full that has happened during the entire negotiation? With due respect, I'm being asked for my vote regarding the motion on the order paper. Are you asking for what is on the order paper, which is any legal advice in full? That is during the whole negotiation. Are you asking? And so it went on. It was not clear. And it strikes me, given the given the importance of these proceedings, given the potential impact on one or more individuals, is it not right that this House should be crystal clear about what is on the indictment, so to speak?
I'm following the honourable gentleman's argument, but can he answer my honourable friend's question? If it was so unclear, one, why didn't he vote against it, or why didn't the government oppose it?
Respectfully, that is no answer at all. It is no answer at all. Absolutely not. If the to take an analogy, if the prosecution were to bring proceedings against the honourable gentleman for an alleged crime, if you would just listen for a moment, if they were to bring proceedings for an alleged crime, if the court was satisfied that the proceedings were bad for duplicity or bad for lack of clarity, the court would stay those proceedings because they would be improper proceedings. And that is what has happened here. There are real concerns about these matters. And in those circumstances, if the court wishes to act, if the High Court of Parliament wishes to act in a way that is proportionate and in a way that is fair, the proper outcome is to refer it in accordance to the terms set out in the amendment. Those are my representations, Mr. Speaker.
Michael Tomlinson.
Thank you, Mr. Speaker, and it's a great pleasure to follow my honourable and learned friend, the member for Cheltenham, and to contribute during the course of this debate. And I'm especially pleased to see the Attorney-General in his seat, because I'm going to refer to one or two of the remarks, because I was concerned by what I heard from the Attorney-General yesterday. I was concerned that he was less than optimistic. He had a somewhat gloomy outlook as to what might happen if the vote doesn't pass a week today. I thought he could be more full-throated and full of voice in defence of what the prospects for our country in the future. Further, Mr. Speaker, where I was sitting in the chamber, concern was expressed as to the length of the Attorney-General's replies during the course of the debate, because we've become used to a short exchange, short questions and short answers. But, Mr. Speaker, the reason for that is because the Attorney-General was being asked his legal opinion on several questions and was giving a full and frank response to each and every one. I have one further concern, and the other members on both sides have expressed this, and that was on the 13th of November, that the motion was not opposed. It seems to me that that was a mistake. It should have been opposed. Arguably, an amendment could or should have been tabled, and had it been voted upon, then that may have solved it. But in the event, Mr. Speaker, there was no vote, and there was no amendment, at least none, that was selected. But the Attorney-General is absolutely right in this respect, not to disclose the legal advice. Where does it leave us if he does? Should he disclose cabinet minutes? Should he disclose official secrets? Or should he disclose any other legally privileged document just because a humble address says so? My instinct would be to say no. Thankfully, Mr. Speaker, we don't have to rely simply on my instincts for this. The Honourable Gentleman, the member for Rhondda, referenced Erskine May. He referred to the 10th edition of Erskine May from the late 19th century. But in fact, it's still, the relevant passage is still there in the 17th edition from 1964. And as no one has quoted from it yet, and as it is absolutely pertinent, it's important that I do so now. And it refers to returns. Returns may be moved for either by order or address relating to any public matter. And it proceeds to qualify what it means by a public matter. It says the papers and correspondence sought from government departments should be of a public and official character and not private or confidential. And it then quotes from an example of confidential papers that should not be disclosed. And then it further proceeds in this way. The opinions of the law officers of the Crown, given for the guidance of ministers in any question of diplomacy or state policy, being included in the class of confidential documents, have generally, and I'll come back to that word, have generally been withheld from Parliament. And then we come to the case from 1858 that the Honourable Gentleman, the member for Rhondda, I wish he were in his place, because he really would enjoy this exchange if he were in his place. We come to the Cagliari case that was referenced from 1858, because the Honourable member for Rhondda is wrong. He said that that was an order of Parliament. It was not. It was voluntarily disclosed. And I can quote from the Hansard records of 1858, from the 15th of March, column 178. And it says in column 178, if anyone cares to reference later, it's towards the bottom on the right-hand side. It says, we have given directions. We have given directions that all the papers connected with the management of the Cagliari case by our predecessors should be prepared and laid with all reasonable dispatch before Parliament. They are more voluminous than the House perhaps imagines, but no unnecessary delay will take place. It proceeds, it is also my duty to state that after great deliberation, while perfectly aware of the inconvenience which under ordinary circumstances would accrue by submitting to Parliament the opinions of the law officers. I'm delighted to see the honourable member return to the chamber. Officers of the Crown, we have arrived at the conclusion that in the particular and exceptional circumstance of the present case, we ought to lay the opinions of the law officers of the Crown before the House. It was voluntarily disclosed, and that is the key and distinguishing feature of the 1858 Cagliari case. But the 17th edition of Erskine May continues. It continues. However, ample the power. The Honourable Gentleman has just entered into the chamber. He may enjoy the exchange. However ample the power of each case to enforce the production of papers may be, a sufficient cause, and the Attorney-General referred to this clause, this section, in one of his responses to my honourable friend, the member for North East Somerset yesterday. A sufficient cause must be shown for the exercise of that power, and if considerations, Mr. Speaker, of public policy can be urged against a motion for the papers, it is either withdrawn, as the Attorney-General said this yesterday, it is either withdrawn or otherwise dealt with according to the judgment of the House. Therefore, having been concerned in three respects by what the Attorney-General said yesterday, He was absolutely and precisely right to have said that a public policy test could and should be applied in this case. And the passage from Erskine May is crystal clear. If the Honourable Gentleman Member for Rhondda were in his place and would say, well, how about it's the 17th edition and not the 24th edition? Why has it fallen out of use? Why has it fallen out of use? Because in the most recent edition of Erskine May, humble addresses had fallen out of use. That has changed, Mr. Speaker. That has changed. And in the next edition of Erskine May, there will be a fuller, I have no doubt, there will be a fuller section. It doesn't mean that it's irrelevant. It doesn't mean the law has been superseded. It means that the humble address had fallen out of use, had fallen out of practice up and until these extraordinary times in the general election in 2017. And, Mr. Speaker, with you in the chair, I'm sure there'll be a footnote, there'll be an extended passage on the increase of the use of a humble address. But that is not to say that the advice and the guidance of Erskine May, from whether it's the 19th century or from whether it's the 17th edition in 1964, is otiose, is useless, is worthless, or has been superseded. It has not. It is still relevant, and it's relevant to the debate today. In any event, the Attorney General gave ample legal advice yesterday. He was crystal clear. He was crystal clear on his concerns about the backstop. He was frank about his concerns about the backstop, and he was absolutely right to say it is now no longer a question of legal precedent. It is now no longer a legal question. It is a political question, and that is a question for each member of the House to debate and to vote upon a week today.
Chris Phil.
Thank you, Mr. Speaker. At the heart of our debate today is a question of Parliament's powers and prerogatives. The Honourable and Learned Gentleman, the member for Holborn and St Pancras, laid out a very simple and a very clear case at the beginning of today's proceedings. He said that the House passed a motion on the 13th of November compelling the government to do something, and he says the government has not done it, and he says that it proceeds simply from those two facts, that the government or ministers are therefore in contempt. I say that that analysis is too simplistic and lacking in nuance, and that analysis presupposes that Parliament's power generally is unqualified and unconstrained. And indeed, two members in this debate have made that point explicitly. The Right Honourable and Learned Member for Beaconsfield described Parliament's power in his speech as untrammelled, and the Right Honourable Member for Rhondda, who I see is at the bar of the House, also suggested that Parliament's power was entirely without limitation. And I would suggest, without wishing to open up an enormous debate on those 2 points, I would suggest that those two assertions cannot be taken at face value as self-evidently the case. For example, the Human Rights Act and the European Convention on Human Rights imposes limitations on acts of Parliament, and any act of Parliament we pass must be in conformity with human rights legislation and indeed with the European Convention on Human Rights. There are limitations on what Parliament may do. And when I put to the Honourable Member, Right Honourable Member for Rhondda, does Parliament really have the right, for example, to trample on somebody's personal liberty, he replied to my intervention by saying, well, members of Parliament could be relied upon not to trample on people's liberty in that way. And yet, when you read the great tracts on personal liberty, and in particular John Stuart Mill's essay on liberty, he urges that we should seek to protect individuals from what he describes as the tyranny of the majority. So I think we need more than simply a reliance on goodwill to protect, for example, individual liberty. And so, and the Honourable Member for Harwich, who's not in his place, also made some reference to the limitations on parliamentary authority by highlighting the distinction in the powers exercised by the executive versus those as Parliament as a legislature. And there are all kinds of areas where the government acts with prerogative power and Parliament does not seek to usurp that power by essentially becoming the government or becoming the executive. So I think there are all kinds of areas where the limitations to parliamentary authority can at the very least properly be debated. The assertion that parliamentary authority is unlimited isn't something one can take immediately at face value, attractive though it is to us as parliamentarians. And of course I in no way wish to fetter Parliament's ability to make its will felt. For example, in the Mark Zuckerberg case, our select committee colleagues were entirely within their rights to summon him, and it is deplorable that the chief executive of such an influential company contemptuously refused to appear before a parliamentary select committee. And I urge the chairman of that select committee to use his good offices to compel Mark Zuckerberg to appear. But in this particular question, a question has repeatedly been posed by members opposite. Well, why didn't the government oppose this measure when it was first put forward on the 13th of November? And I would suggest a reason for that. The reason for that is that in order to properly debate what parts of the legal advice might be disclosed or might not be disclosed, you would have to disclose the legal advice itself. You would have to examine what the legal advice said before deciding what could be disclosed and what couldn't, and the very act of debating it would cause its disclosure. And that is why when matters of disclosure arise in a court of law, they are decided by a judge in chambers, not in open court, and the judge then decides what can be disclosed and what can't be. No equivalent provision existed when the House debated this matter on the 13th of November. It would have been a case of disclosing everything and debating it openly, or disclosing nothing. There is clearly a tension between the desire of Parliament to get disclosure and the desire of the executive to protect the public interest. And the question is, how do you balance those two competing considerations? And a number of honourable and right honourable, just a moment, a number of honourable and right honourable members today have suggested that there are various appropriate fora in which that might occur, one of which evidently is the Procedure Committee, or indeed some other committee of the House, who might, behind closed doors, look at the legal advice. I'll take the intervention.
He's talking complete nonsense. The idea that the government would have had to disclose the evidence in that debate to vote against, isn't it the fact, the reason why they didn't pose that vote is because they would have lost it?
Well, the honourable gentleman is engaging in speculation. The fact is that when matters of public disclosure are considered in other environments, for example, a court of law, it is an independent person, in that case a judge, who in chambers, in private, decides what might publicly, I must conclude because Mr. Speaker I think wishes to move on with the business, decides what gets publicly disclosed. No such device, no such mechanism was available to this House on the 13th of November. And it strikes me that the Procedure Committee is a suitable forum in which that balance can be struck, the balance between the desire for disclosure and the public interest. And it's appropriate that balance is struck in private. Mr. Speaker, I will therefore be supporting the amendment this evening, and I know that the Speaker wants to move on, so I will conclude my remarks there.
Mr. Kevin Foster.
Thank you, Mr. Speaker. And it's a pleasure to be called in this debate, having following so many learned, honourable and right honourable members who've already contributed. I must say, I did enjoy some of the contributions from the Scottish National Party benches around the idea of Parliament being supreme. Given, they'll remember the famous case of McCormick versus the Lord Advocate, where they say that complete parliamentary supremacy is actually an English concept, but not necessarily one of Scots law. So it's great to see their conversion now they have come here. But turning to the actual matter of substance, and I sat through quite a lot of that debate on the 13th of November and noted the numerous points that were picked up about how the motion passed then had various queries raised about it. And the thing, I'll always happily give way to the leader of the SNP.
I'm grateful, and I want to give assistance to him by giving him the exact quote, which is that parliamentary sovereignty is a purely English concept that has no counterpart in Scottish constitutional history. And of course, this House endorsed a motion pushed by the SNP some months ago that sovereignty does rest with the people of Scotland through the claim of right. And I trust if this government seeks to try and take us out of the European Union, and the only way that we can protect our interests by becoming an independent nation, it will endorse our rights to call a referendum.
Well, can I very much thank the right honourable member for that intervention, and yet again reminding people in Scotland that the focus of the SNP is Indy Ref 2 and is around separation of this union. And so it's always ironic to hear them calling for an end to borders in Europe, but they want borders on this island. It's always a true irony. But I'm genuinely very grateful for that intervention, and I know my Scottish colleagues be even more grateful for it and been able to put it in their next leaflet. But in terms of moving back to the subject of what we're discussing here today, is about the motion before around contempt. And I have to say, like some previous speakers, I do find it rather interesting that even before the Attorney-General had managed to sit down, some people had concluded that he was already in contempt. And I do find it rather bizarre that, here we are with an opposition who, I have to say, doesn't strike me as short of the ability to find very senior and very experienced lawyers to analyse the withdrawal agreement, its implications and what it might mean for the future. In fact, we only have to bluntly look at the front bench currently to see a very eminent QC sat on their front bench, now effectively arguing that they're not able to make a reasoned judgment on this without the legal advice, not the legal position of the government. That's quite right, that this House should always be able to demand that the government sets out the legal basis of its actions in this Parliament. We are a country that's defined by rule of law, and that's why it is right legal positions can be requested and demanded. But it's now effectively saying that what we need is the government's lawyer to tell us what the legal implications are, or the legal advice is on this area. And for me, I think that, this is not an area where we're going to be short. And I think it was an excellent speech given by both the members for Cheltenham and by the member for Mid Dorset and North Poole, who make very clear the key points about what actually this motion is about. I also particularly enjoyed the speech from the honourable member for Witney, who again made the distinction between disclosure, which is a very strong point of criminal law, and actually civil cases as well, where making sure that evidence is not being concealed, as opposed to privilege around legal advice. When I used to give legal advice, the run-up to cases in places like Solihull Magistrates Court, there was no forum to actually ask for what my advice was. Clearly, I couldn't conceal evidence. I couldn't, for example, go and run a line of argument in court that I knew to be untrue. As many of us know, and I know the Attorney-General's place will have heard that as many other members of the House, the old adage of what happens if a client tells you they're guilty. Well, that means you cannot run a defence. You can test the prosecution's case, but you cannot run a defence in court or mislead the court. But you cannot be required, though, to give over and to overthrow your legal privilege, to have your legal advice out there. And I think, to be blunt, it's a quite worrying trend now that this is what the members of the opposition want to attack, is that right to legal privilege. I'll happily take intervention.
Very grateful indeed to the Honourable Gentleman. Thank you, Mr. Speaker. I wonder if the Honourable Gentleman would deal with the assertion, accusation, suggestion, allegation made by the DUP that if the government is not prepared to publish the full legal advice given by the Attorney-General, that somehow the government has something to hide. I think that has to be addressed in this House before we vote.
Well, thank you. And I thank the Honourable Lady for her intervention. I think, to be blunt, anyone who listened to the statement from the Attorney-General yesterday would have been hard-pressed to think that he had something to hide, given he was very open about some of the challenges with the withdrawal agreement, particularly areas around the Northern Ireland backstop that I know will be of immense concern to the Honourable Lady, about what that means. And there was not one word there that I would say was actually holding back on what he thought of the legal position on the backstop. And I don't think, and of course, again, as a very senior barrister, I do not believe for 1 minute he would have come to this chamber and given a legal position that in any way conflicted with the legal advice he had given in terms of the Cabinet and the Government. And that's where I think that needs to be very clear, as I don't believe there is anything to hide. This wasn't a statement saying why it was legally why it might be a good idea to sign this treaty. It was saying why the legal position that there was. And there's no one in this House is arguing that this Parliament doesn't have the legal power to sign this if it wishes to ratify this treaty that the government has negotiated. The debate is fundamentally whether we think it's a good idea to do so or not. And there's obviously very sharply differing views, not just across the chamber, but bluntly on the government, between the government, but as well, whether it's a good idea. But nobody is arguing that this is not a legal thing that the government could not seek to do and could not lawfully do based on our Constitution. She's absolutely right to say that I don't think there is anything that was hidden. The attorney was very clear about the legal position, very clear about the backstop, very clear with colleagues' queries, and I don't believe for 1 minute that any word of that would have conflicted with what he had said privately in terms of legal advice. But that is the difference. Position is very different to advice. Evidence is different to a lawyer commenting with their client on the evidence, and then giving them advice of what that may mean. And if we start getting to a point where we use this idea that the attorney's advice will end up out in public, what we'll actually see is a trend to things not being written down, things being said verbally, not having proper records, not being able, perhaps at a later date, after when it might become relevant, to be able to access some of that. And again, moving away from the idea that some of the key principles of law, which include legal privilege, do not operate in the same way in government as they do outside. So for me, turning to this actual motion itself, and I do find it interesting the way this has been pushed to be on today. I accept that's all part of the procedures of the House, perfectly properly followed. But it does, for me, make much more sense that the Committee of Privileges actually has a proper investigation and consideration, rather than effectively we decide whether someone is guilty of contempt via a jury of their political opponents, and we're following quite a party political knockabout in this chamber. And that's, for me, why I think the amendment has strength. This is not about saying, let's just vote no and forget about it. This is about saying that actually asking the proper process of the House to be gone through. For those following our proceedings, it's a committee chaired by an opposition member. It is not a committee that is purely going to follow what the government will might be. And that is where, for me, the strength comes of the amendment in actually having to have a proper debate about this clash of principles, this clash of legal privilege, the position of the law officers, and the position of this House to pass returns and to make the humble just request for documents. I accept that nobody in this House would think it would be a sensible idea to have a humble address for MI5 documentation or for sensitive diplomatic papers, and I wouldn't seek to advance that. But in this instance, we have those things come together at a time when actually anyone who wants a legal opinion on the withdrawal agreement will not be short of suggestions coming into their email inbox from various eminent lawyers across the country as we speak. I think I'll come towards my conclusion, because I'm conscious there are one or two others waiting. I hear from the Scottish National Party benches a request for more, but sadly I'm going to have to disappoint them. But for me, that's why I think the amendment is the right path to go down, is that it allows a proper consideration of this, not a short-term debate 24 hours after a statement on the floor of the House, but allowing a proper committee to consider these matters and then to see if it has been fully concluded with. And as I say, particularly it was interesting to hear the Father of the House, the Right Honourable Member and Learned Member for Rushcliffe, which again gave some ideas as to how matters like this could be handled in future. But with that, Mr Speaker, I will conclude my remarks and say I think the amendment is the right way to go, and I do think that there's been some quite interesting arguments this afternoon that I hope members will reflect on what the precedents they might set for a future government of their own colour.
Mr Simon Hall.
Mr Speaker, let's be clear that contempt is not disobeying an order. In fact, if you look at the tweet, Mr Speaker, put out on the UK House of Commons Twitter account today, it defines contempt as being an act or omission which obstructs the House of Commons in carrying out its duties. That can be seen as a contempt of Parliament, and that's an incredibly high bar. And I don't believe that the Right Honourable the Gentleman Member for Holborn and St Pancras has made his case before the House this afternoon. Mr Speaker, you and I love this place. But there is nothing, I think, more humorous than the synthetic confection of outrage, umbrage and humbug. Sounds like a rather dodgy firm of solicitors that comes from this place when it thinks that its honour has been offended. It draws up its skirts like a slightly shocked maiden aunt at a risque joke. And the opposition have, I'm afraid, turned this into a parlour game. It's a parlour game called parliamentary politicking, or it's a parlour game called parliamentary process. Let me pray in aid one or two cases, or one or two thoughts, which I believe substantiate that viewpoint. So great is the umbrage of the opposition that they ran out of speakers about 50 minutes ago. That strikes me as being not exactly as hot under the collar as the Right Honourable and Learned Gentleman tried to portray them as being. Yesterday, when my Right Honourable and Learned friend, the attorney, invited any question from any member on any topic, about 75% of the stuff was to do with process and nothing to do with questions. And if the Right Honourable gentleman, the Right Honourable and Learned Gentleman who spoke from the opposition front bench, was serious in his, I have to say, entirely synthetic sincerity about being more in sorrow than in anger, why was he trailing his letter around last Thursday and having it signed and sealed by close of play last Thursday? I thought a former DPP would believe in honesty in the courts and listening to somebody give their case before deciding what the next step would be. But he went around this place like a political costermonger, selling his wares. I won't. Go on then.
Mr. Speaker, the honourable member's talking nonsense. That letter wasn't signed on Thursday.
Absolutely. Was it passed around?
The Right Honourable and Learned Gentleman, Mr. Speaker, was tarting his letter around this place, trying to get signatures on it during Thursday to instigate a contempt proceedings. Now, he may not have put it in the envelope and got the stamp out, but he had the letter drafted. Not only had my Right Honourable and Learned friend got up for about 20 minutes, then the letter was being handed in to say, let us have a motion for contempt. Well, I've heard of a judge trying to come to the definitive view, the final judgment, but not when the prosecution or the defence is still trying to make their case. What sort of a lawyer the Right Honourable and Learned Gentleman made begs the question. I have also heard, Mr. Speaker, the Right Honourable and Learned Gentleman and the Honourable and Learned Lady for Edinburgh South West make incredibly powerful cases, in support of privilege. They did it during the course, though not exclusively, of the Investigatory Powers Bill, which the Right Honourable and Learned Gentleman and I sat on in committee. And he was absolutely right to talk about the sanctity of privilege, in that it was in the lawyer-client relationship, and also a journalist with their source. But it seems that the Right Honourable and Learned Gentleman wants to cherry-pick which bit of privilege is important or not. This is, I won't because I'm very conscious of time, this is a parlour game. We are not going to play it. We are going to support the government's amendment, and I think we are then going to move on, Mr. Speaker, to actually do what this country is expecting us to do, to debate with the sobriety and seriousness which the issue demands, and that is the exit of this country from the European Union.
Keir Starmer.
Thank you, Mr. Speaker. I'll wind up very briefly. I've listened carefully to debate. There have been some very good points made and some very bad points made. Mr. Speaker, we on this side are well aware of the two principles laid out by the Father of the House. Firstly, that only in exceptional circumstances will privilege be overridden, and secondly, that orders of this House should be complied with. November the 13th was about the first principle, and the government didn't oppose the order. Today is about the second. We have been careful in this motion in drafting it to refer to ministers rather than individuals to reflect some of the points that have been made in this debate. We've also been careful to ask the remedy, and that is that the order is complied with before we think of anything else, in fairness to the government. The Father of the House said, surely there must be some mechanism, some way that this can be agreed in which the order can be complied with, and lots of members and honourable members, right honourable members, indicated that. What I can say is in the 3 weeks since the debate about the first principle to today, no suggestion has been put to me by the government of any sort of mechanism to enable them to comply with this order, and the House will make of that what it will. And for that reason, I must push this motion. Thank you.
Thank you. The question is that the amendment be made. As many as are of that opinion say aye. Aye. Of the contrary, no. No.